All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director at the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for becoming an advocate for military veterans. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you registered and were unable to attend, or if you were able to attend, you're still going to get an email from Zoom next week with the link to the recording, with the link to the materials. I'll also be posting it on YouTube where I'll include the materials as well and the CLE code information. So speaking of CLE codes, this training was approved by the Florida Bar for 3 general CLE and 3 state and federal government and admin practice certification credits. So as I said, I will announce the CLE code towards the end. I'll drop it into the chat. For whatever reason I forget, don't worry because you're going to get an email with the code and you're also going to see it on the YouTube description if you check out the YouTube recording. So closed captions are enabled for anybody who needs them. So if you're having any issues with captions, you can let me know and via chat, via email, and you can reach out to me directly. This training is being co-hosted by the Public Interest Law section of the Florida Bar or PILS. So if you're not familiar with PILS, I encourage you to take a look at our website. I'll drop the link into the chat as well. I'll make sure to include the links to our website in the email that goes out from Zoom as well. So this is a 3-hour webinar. So we are planning to have like 2 breaks at the hour mark. So our speaker will let you know when it's time for the break. So just make sure that when we do set the break to come back in time for the webinar. So questions and answers. If you have questions during the webinar, I can't bring you off mute until the end, but feel free to use our Q&A feature, or you can use the chat feature, whichever one is easier for you. I'll turn off my video as soon as I pass it on to our speaker. But I'll be here the entire time. I'll be monitoring the chat. If I see that there's a question that is related to the materials or the slides, I'll probably come off video and let our speaker know so the question can be addressed. But otherwise, if you have any questions, make sure to use those features so we can, if time permits, we'll address all of them towards the end. So this time, instead of introducing the speaker myself, I'm going to pass it over to my amazing colleague, Christy Bagalow. I'm really lucky to be reunited with Christy when I started my career. Christy was one of my first mentors, so I'm really lucky to not only I started my career with Christy, and now I'm reunited with her again. So to introduce our speaker, I'm going to pass it to Christy Bagalow first. So Christy, the floor is yours.
Thank you, Jorge. I appreciate you giving me the honor of introducing our speaker today, James Heaton. So as a lot of you know, he is a superstar of the nonprofit veterans world. He's the vice president of Mission United at United Way of Broward County and the owner of the Veterans Benefits Law Firm. His practice focuses on military and veteran benefit appeals at the agency and federal court levels. James is also an adjunct professor of law at Nova Southeastern University, Shepard Broad College of Law, teaching the Veterans Law Clinic. So if I'm counting correctly, that's 3 jobs. So thank you for being here today with us for 3 hours on top of your 3 regular jobs. I do encourage everyone to look up Mission United. It's a really unique partnership and it's spreading throughout the country and throughout Florida. So check that out. Outside of his practice, I don't know how he has time outside of his practice, all these 3 jobs, but he is an active member of the Broward County Bar Association as a co-chair of the Veterans Committee and past president of the Young Lawyers Section. James is also past chair of the Florida Bar's Military and Veterans Affairs Committee. So welcome, James. Thank you so much for being here and teaching us today.
Thank you, Christy, so much for that introduction. Yeah, lots of jobs. Also have a 3-year-old, so it's, we'll count that as 6 jobs total then. Thank you, everyone, for joining the webinar today. A couple additional housekeeping matters that I want to address first. First and foremost, this is being recorded for anyone watching on YouTube in the future. This is being recorded in November of 2025, which means make sure you're checking updated law. Everything on this slide should be updated as of the date of this recording. Second, it's November because I'm rocking the mustache for November. So that's how you'll know it's being recorded in November. The other point of housekeeping is that this also qualifies for the VA Accreditation CLE. So in addition to 3 credits that you can receive through Florida that's been approved, you can also get your VA accreditation met as well through this CLE. So without further ado, we've got a lot to tackle today. As mentioned, we will be having a break around the hour mark and then around the 2-hour mark, and then we'll bring it all home. So let's get started. So we've got a few objectives for today. And as we go through this, if questions come up, please make sure you put them in chat or put them in the Q&A. But the objectives of today, we will be talking about, what is the Department of Veterans Affairs? Who is a veteran? What does representing parties before the VA look like? What are the benefits available? And how does the appeals process work at both the agency of original jurisdiction and at the federal court level? Here's some references. And again, this will all be shared out. Some references that we bring up throughout this webinar today. So no need to write all these down. We'll make sure we share it all out. It's certainly something that's useful. Big shout out to National Veterans Legal Services Program and the Veterans Benefits Manual. Huge help for any attorneys, any advocates learning the law. We use it on a regular basis in our legal clinic, and it is wildly helpful. So let's talk about some common terms as well. You may or may not be familiar with some military lingo. There's some things that come up throughout the slides that may not be listed here as well. But I want to talk about some of these common terminology. So service member, someone who's currently serving in one of the branches of the military. Service members may have specific names depending on their branch. If they're in the Army, they're called soldiers. In the Navy, sailors. Air Force, airmen. Marine Corps, Marines. Maybe some other derogatory names. Coast Guards are guardians. Just something to keep in mind. A veteran is someone who previously served in the military. We got to start with the basics. We have some distinguish between enlisted and commissioned positions. So enlisted are really think of the working force, and commission being the professionals, if you will, of the military. No offense to my enlisted friends out there. Reserve component is separate from being a full-time active duty service member. It's usually a part-time, still contracted service, but on a part-time basis. Things that really matter: character of service. It's a term of art that is the discharge classification, which we will go into depth today of what that means. One thing you'll hear me say a lot, and I'll try not to use acronyms all the time, but that's what happens in this line of business, is I'll refer to other than honorable discharges as OTH. You'll hear that a lot and understand what that means by the end of this presentation. Narrative reason for separation is another term of art that we use, and it's why or how somebody left the military, the reason why they left the military, if you will. Service connection is a disability that the VA provides, a disability benefit, or specifically a disability that's adjudicated by the VA to be related to someone's military service. We have VA pension that we talk about. It's a benefit that's available to certain wartime veterans who are low income. Separate from military pension, but we'll talk more about what VA pension is later. A couple more acronyms. We have the AOJ, that's Agency of Original Jurisdiction. That's an administrative law term, which just means the originating body of an administrative action. Here, the AOJ is going to be the Department of Veterans Affairs. We also have the VARO or RO, that's the VA Regional Office. That is the specific part of the Agency of Original Jurisdiction. That's where these claims begin. So you may hear VARO, you may hear RO, you may hear Regional Office, you may hear AOJ. For the purposes of this presentation today, they're mostly interchangeable, but we'll get into some more details later on. So here's some important things to note. Typically, the benefits clients that are served in this area are coming from an enlisted component. Not saying that you won't get commissioned officers that come to you for benefits help, but the overwhelming majority of clients, at least that we see down here in South Florida, are enlisted, coming from an enlisted component. Your mileage may vary. And most clients were on active duty and had some reserve time, but weren't mainly reservists. Most of our clients came from an active enlisted component. And this area of law almost exclusively operates under federal administrative law, Title 38, both for the Code of Federal Regulations and for the US Code, are going to be your friends for everything that you need. If you're practicing discharge upgrades or other military law like Christy does, you'll have different titles that govern as well as Title 38. But for the purpose of this PowerPoint presentation, Title 38 is your friend. So let's start off in the beginning of time with an overview of the Department of Veterans Affairs. So a little history of the VA here for you. So the original system for VA benefits, it's established around the end of the Civil War and was really created to handle three different aspects through three separate government agencies. And those are the Veterans Bureau, the Bureau of Pensions of the Interior Department, and the National Home for Disabled Volunteer Soldiers. In August 1921, after World War I, Congress consolidated all the veteran services into just the Veterans Bureau. However, they still kind of existed in three separate tracks handling these three separate functions. You'll see why that matters in just a moment. And in 1930, the Veterans Administration was created through an executive order. And that was thanks to the Hoover administration. Moving forward to 1988, there was a tag team Reagan-Bush effect over here where the VA was elevated to a cabinet level position and became the Department of Veterans Affairs, which it is still called today. Now, at the time, nearly 1/3 of the US population was eligible for VA benefits, which is kind of wild to think about. And through further consolidation, the VA oversaw three distinct departments. And this is still how the VA looks today with these three separate departments, the VBA, the VHA, and Veterans Cemetery Services that are kind of modeled off that initial post-Civil War construction of the program. Now, these three different functions handle three distinct different types of services. So the Veterans Benefits Administration, or VBA, handles the initial veterans benefits claims and appeals, and they also determine eligibility for VA benefits as well. So even if someone's coming through the healthcare arm and needs to be determined eligible, it'll be handled by the VBA, or supposed to be handled by the VBA. The VHA is the Veterans Healthcare Administration. They handle, obviously, healthcare services and community-based services as well. Think of the VA hospital or outpatient clinics in your community. It's a VHA. And there's some collaboration between VHA and VBA. Obviously, they have to talk to discuss eligibility and what services may or may not apply and what benefits may or may not apply to a veteran that's in front of them. However, they don't really share a integrated system, which makes things a little difficult. And then we have cemetery services. They handle burial benefits. For the purposes of this webinar, we will not be getting too much into cemetery services, but just understand they handle burial benefits for veterans and their families, and they have a process to apply for those benefits in a pre-need basis, so before there's a decedent involved. So let's talk about getting into it, representing parties before the VA. So here's some of the things that you'll need to know about accreditation, fee agreements, forms that are used, and something called the Veterans Benefits Management System. So talking about accreditation at the VA regional office level, the accreditation program exists to make sure that veterans and their families receive appropriate representation, so that people aren't just running around, sharking veterans for claims. Unfortunately, it still happens today, but making sure that an accredited representative and attorney is actually accredited is very important for your clients to do. They can go on the VA website and double check all of that before engaging a counsel or an advocate to help them. The VA accreditation under the regs is solely for the limited purpose of preparing, presenting, and prosecuting claims for the VA. It's not to put on your website to say, I'm a VA accredited attorney that also does family law, or I'm a family law attorney that's VA accredited. The VA does not like you doing that. It's actually against the regulations, so please don't do that. Only use your accreditation for good. The VA Form 21A is where the accreditation process begins. So you'll have to use the same information on State Bar's website to get accredited through the VA. It's a fairly straightforward process for attorneys. It's pretty much just filling out that form and answering some questions and providing some additional supporting documents that you are actually licensed to practice law in a jurisdiction in the United States. And standards of conduct are found in 38 CFR 14.632. You'll find everything you need there about standards of conduct, what you should and should not do as an accredited representative, what you can and cannot do. There's a lot of good information there, including what needs to be included in this type of presentation to be counted as a CLE credit for VA accreditation. For those folks who are accredited today, like I mentioned, you'll be able to use this for continuing legal education with the VA. If you are not yet accredited but want to be accredited, go ahead and do so. Get yourself accredited to represent veterans after getting so inspired after this presentation, but then you'll have to go ahead and watch it again. So watch it one time and like it so much that you watch it again. The date of watching the CLE must be later than your date of accreditation. Questions can be sent to this mailbox. They're pretty well responded to as well. Now, for admission to the Court of Appeals for Veterans Claims, which is the federal court that handles cases after they have left the agency of original jurisdiction on appeal, it's a little bit different. There's it's federal court, so there's rules. Rule 46 of the Court of Appeals for Veterans Claims outlines the general rules for practicing before the CAVC. To seek admission, you have to qualify. And then there's two parts of qualification. There's good moral character, and there's active status with the state bar, both governed by 46A and 46B respectively. And you can apply for admission online. You pay a small fee. If you pass the good moral character and active status with the bar, you will then be admitted to practice before the Court of Appeals for Veterans Claims. There is no requirement that you are both a VA accredited practitioner prior to practicing before the court. Obviously, best practices would say that it's good to be both accredited with the VA and admitted to the Court of Appeals for Veterans Claims. We'll talk more about that as well when we go through the procedure of how a case, the lifespan of a case. Now, how do we make money here? We can have some fee agreements. If you're an accredited agent and attorney, you can charge a fee for your services. However, there are some pretty specific rules that are strictly enforced when regarding how and when fees can be charged. Unfortunately, like I said, there's some people that take advantage of this situation and they shark veterans and charge them money that they should not be charging them. And it's very unfortunate, but here are the rules. So direct payment under the regulations can only be paid for a reasonable attorney fees after an agency of original jurisdiction has made a decision on a claim. The attorney has complied with the power of attorney requirements under 14-631 and the fee agreement requirements that are in 14-636G have been satisfied. So once all three of those things have been accomplished, you can then seek a fee. Now, what is the fee? What do fees look like here? You can't charge as an attorney for an initial filing of a claim. Technically, can't charge more than $20 for it, but you can charge for an initial filing of a claim. Now, rates up to 20% of an award. If your fee agreement says that you agreed to 20% of retroactive payment from a VA benefits claim, then that is considered presumptively reasonable. Rates above 33.33% of an award are presumptively unreasonable, and though the presumption is rebuttable. However, the VA will pay you directly from the benefit retroactive award if your rate is up to 20% inclusive of fees. So if if your fee agreement says 20% and your client receives retroactive pay for their benefits on appeal, you will be entitled to 20% of that paid directly to you from the VA. If it's 21% or more, then on your fee agreement, the VA will not pay you anything directly. You'll have to get that directly from your client. That's how it's supposed to work. Again, your mileage may vary with the VA sending you checks or not. Talking about other fees, how else can we get paid in this area? Understanding that all of you will be doing this on a pro bono basis, I'm sure, not trying to make money, just trying to help the world. There are other fees that can be received as well through federal practice. The Court of Appeals for Veterans Claims and several other federal courts follow the guidance of the Equal Access to Justice Act, or EJA. And the EJA allows practitioners who are prevailing parties to get fees paid for directly by the government. The fees are separate from the fees that you would receive in retroactive claims paid by the AOJ. That would be money that's normally gone directly to the veteran. EJA fees don't impact that. So EJA fees aren't money that would otherwise go to the veteran. This is a separate pot of money set aside by the government to help incentivize representation of parties that, in claims that otherwise wouldn't really have any contingency value to them. Now, to calculate EJA fees, you've got to have a master's degree in math or a good calculator. You have to submit detailed billing logs. Calculated hours must be reasonable. Hourly fees are statutory, though there are allowed increases for local factors as well. I believe EJA fees in South Florida right now are like $292 an hour. Obviously not terrible. It's a great way to help out clients. If you're doing it through a pro bono program, those fees can be donated back to the pro bono program as well. If you're doing it through the clinic setting, understand that only attorney hours can be calculated for billable, but any dollars that are made through EJA fees can be donated back to your program as well to help offset any costs of running these programs. So it's a great additional way to fund programs as well. Let's talk about some VA forms. This is administrative law. So in admin law, everything is form-based. If you've practiced immigration law before, tax law before, Social Security disability benefits, you understand the power of the form. Everything starts with a form. Even as suggested, you should use other documents to support your forms. Everything's attached to a form in some way or another. It's the best way to get things through to the VA, and it's required in the majority of these types of cases. So let's talk about some common forms here. Everything, for the most part, is called VA form something. So you'll hear me say VA form 2122A, or maybe just 526EZ. Some of them have colloquial names to them, but these are the actual names for these forms. So VA form 2122A is the appointment of an individual as the claimant's representative. That is your form essentially allowing the VA to recognize you as this individual's attorney. It'll give you access to certain records. On the form itself, you can limit representation or expand the scope of representation based off of the boxes you check and what you write in the blank. So it's a great form. It also is the key to get access to the individual's online electronic claims file through the Veterans Benefits Management System. More to come on that in a second on VBMS. We have the 526EZ, which is the application for compensation benefits. You'll know the difference between compensation and pension benefits very soon, but just know the 526EZ is the most common application for filing for disability claims that a veteran uses when applying for VA benefits. As mentioned, you can't charge as an attorney any more than a real nominal fee for applying for benefits. So there's other great resources for veterans to apply for initial compensation benefits. There are plenty of law firms that do help with applying for initial compensation benefits at no cost to the veteran as a courtesy, but just know it's not something that you can charge money for. And we also have the 21-527EZ, which is an application for pension benefits, similar to its predecessor above it, but for VA pension. 534EZ is the application for survivor's benefits, another benefit that we'll talk about in this presentation today. And then we have two more that are kind of, they're forms that are used during a claim. One is the statement in support of a claim, and the other is statement in support of a claim for PTSD. This is essentially if you want to get something in there, whether it's a statement from your client or an expert witness or a doctor, perhaps, even if it's written on the doctor's letterhead, it should still be accompanied by a statement in support of a claim form. Is it required? Not necessarily. Will it get lost if you don't attach it to a statement in support of claim form? Maybe. Will the VA say sometimes that they won't accept it because it's not attached to a form? That certainly has happened before. It's always best practice to include it, the form as well. Now let's talk about the VA's internal case file management system called the Veterans Benefits Management System. I don't know how much Christy remembers this, but I put together a handy guide to get VBMS access several years ago, which included about a 30-point checklist of things you need to do, which reminded me of the game's Chutes and Ladders. It's gotten a lot easier now that it's become more mainstream and more accessible, but the VBMS is the electronic system used by VBA to manage all VA benefits claims. It also houses all of the electronic case files and claims files, also known as the C file, for all veterans who have ever gone through the VA system at all. Even if they've never applied for a financial benefit, if they've gone through the healthcare through a VA hospital or clinic, they've had their eligibility determined, and that evidence will be in VBMS. It'll be in here in their claims file. This system began back in 2010 as a pilot project out of the Providence VA regional office to really help practitioners and everyone else more easily access the VA claims file. Prior to that, they were all paper files, and you'd have to do a FOIA request or go into a regional office and request copies of these claims files. By the year 2013, pretty much all 53 of the VBA regional offices were processing claims through VBMS, which is great. Today, everything's on VBMS for the most part, and it's a wonderful thing to access. You get to get VBMS access, you can apply online. Then you have to go through a review process. You have to essentially get the same type of clearance and background check as you'd get as a federal employee. Fun fact, they will tell your current employer to sign off on you on a form that surely looks like you're leaving your job. So make sure you talk to your boss or HR first before you apply for this, because they do send out the same form that they would send out on the same thing, the same form that says application for employment with the federal government that your boss will get and have to fill out. I'll just tell you from experience, make sure your boss knows that you're not trying to leave the office. And then you get a VA PIV card at the end of the day. And this is what you use to access your the Veterans Benefits Management System for any clients that you are the attorney of record for. So a couple things to note: you can only access records if you have a 2122A on file. So if you have a veteran, if you practice this regularly and you have a veteran coming into your office and you're not their attorney of record, you won't be able to go into their VBMS. There are other ways that you can access portions of their claims file through an online portal that the veteran has access to that they can potentially pull up in your office. But VBMS is the same system that the VA uses. So it has all the notes, all the progress, everything that's happened in the case right there at your fingertips. Certainly useful. And in fact, I would say yeah, it's required if you're going to be practicing this in any capacity. So VBMS access, it's a little bit of a pain to get, but it's not too bad. I actually had a technical issue with the VBMS system earlier last year, and actually January of this year, and I had lost my access for a few weeks, and I had to go through the whole process again. And it took me 6 weeks to go from not having VBMS access to getting it again. So it's not as bad as it used to be. I'd say 6 weeks seemed pretty quick, but I had to stay on top of it because I need that access. I'll give you guys one as well. If you are interested in practicing this full time or are practicing this in some real capacity and don't have access to VBMS, but you want it or have had trouble getting it, reach out to me and I will help troubleshoot you on how to do it. All right, let's talk about some of the most common benefits that we see being applied for through the VA benefits process. So when we talk about common VA benefits, this is not an exhaustive list. Again, this is a very introductory overview. So there's a lot of nuance and a lot of layers in this area of law. And I want to make it clear that this isn't everything. This is just the most common. These are the most common things that you will see. If this is all you knew, you could probably be a pretty decent VA benefits attorney. However, you would probably miss a lot of issues that come up. So it's important to know that there is more digging and more learning that you'll need to do. I would love to one day offer a more intermediate or advanced course on this stuff, but this is a beginner's course, an introductory course to VA benefits law. So we're going to be talking about these three main benefits. The first being service-connected disability. The next being non-service-connected disability or VA pension. And the third being dependency and indemnity compensation or DIC. So let's get into it. Service connection. So service-connected disability is a benefit, a monetary benefit, paid directly to veterans by the Department of Veterans Affairs, by the government, for injuries that for injuries that they sustained while in the military. It can be different types of service connection can be received here. The most common, I'll say, is direct service connection, but it can be secondary service connection or presumptive service connection or aggravated service connection. We'll get into a little bit of each of those. And there's three elements to remember for service-connected disability. You need the diagnosis of a disability. Obviously, you're applying for service-connected disability for a specific disability. So you're applying for a back condition. You probably want a diagnosis or a diagnosable disability of a back condition. which can include the veteran doesn't have to go and find shop doctors until he or she gets a diagnosis, but having the symptoms. I have a hurt back. Great. There you go. Great. You have a diagnosable disability, most likely. Second is an in-service event. You've got to have something to point to that happened while you were in the military. I've got a hurt back. Oh, I got in a Jeep accident. Well, there you go. There's your in-service event. I have a hurt back. I was playing basketball. Great. There's your in-service event. And then the third thing you need is a medical nexus. That's the medical evidence that ties it all together. And we'll get into a little bit more detail of all that in just a moment. Next, we have non-service connected disability. We're going to do a quick overview about VA pension here. This is what it's called, VA pension. Sometimes it's called non-service connected disability. I like to call it non-service connected disability because when I open my mouth and say VA pension to somebody, they go, oh yeah, I'm getting a pension. It's like, no, it's not really a pension. It's kind of misnamed. So non-service connected disability, it's a means tested benefit for certain eligible wartime veterans. It's very similar to SSI, but not exactly the same. So elements of non-service connected disability here are the three of them. You had to have served at least one day during a qualifying wartime period. And if you're curious about what a qualifying wartime period is, make sure you're looking up Title 38 regulation for qualifying wartime period. Immigration law has separate qualifying wartime periods for citizenship purposes. There are other regs out there that have qualifying wartime periods. Make sure you're looking up the right ones that fall under for VA pension. The second element is that the veteran has to be over the age of 65 or permanently disabled or receiving, disability benefits as shown through receiving permanent disability benefits through a common government disability program. And third is the total countable income must be below what they call the maximum annual pension rate. And we'll get into a little bit of the math again a little bit later, but just know it's for low income wartime veterans who are either disabled or over the age of 65. One thing that's happened recently that I find kind of interesting, and for anyone with a calculator in hand, is people who are 65 years old are now no longer going to always be wartime veterans. So for a while, if you were over the age of 65, you probably served in Vietnam or Korea. But it's not like that anymore. So we're getting into a new era of folks that don't just qualify for VA pension when they're low income. It used to be when a veteran walked in the door, when we were at Legal Aid, veteran walked through the door and they're at age 66 and they're like, I have no income. Hey, chances are you served during a qualifying wartime period at least one day. You're now over the age of 65. You have no income. Let's get you in for VA pension. It was the easiest thing to do to get a little bit of income to their name to start them off to get them housing and work with other agencies out there. However, it's not the case anymore. We're finding more and more veterans maybe meet the second and third element, but not the first one. So maybe they served after Vietnam during a peacetime or during the Cold War, which is not considered a eligible qualifying wartime period. So they're over the age of 65. They don't have the income, but they don't meet the qualifying wartime period. So it's things are starting to change a little bit now. It's becoming a little bit more difficult, unfortunately. And the last of the three benefits that we were talking about was dependency and indemnity compensation, or DIC benefits. DIC benefits are useful as well. And they're paid to surviving dependents of a veteran, whether it's a surviving spouse or eligible dependent child. For a veteran who died in the line of duty or died due to a service-connected disability or complications arising from a service-connected disability. It pays a little bit of money. The rates change for this as well, so make sure you look it up online. And there's another dependency benefit that is done through VA pension as well that we're not talking about today, but I think I actually do bring it up briefly, called a widow's pension or death pension. The VA loves naming things. So that's something to keep in mind as well, that if you have a surviving spouse coming in who's the decedent, the veteran, would have otherwise qualified for non-service connected pension, and the widow is low income, the widow may be eligible to receive something similar to the VA pension. So let's talk about a little bit more about some eligibility for the VA benefits themselves. And we're going to go into greater detail about all of these benefits in just a little bit. This was just kind of an overview, so you know what's out there. So when we talk about eligibility, you can say, oh, this is what they're trying to get eligible for. To kind of put a bow on it all, service-connected disability is mostly what your clients will be seeking. It is for the most part, the best of the three benefits, or the best of the monetary benefits that are paid out by the VA to veterans. So this is for the most part what your clients will be seeking. This is for the most part, if you take these cases on appeal through a pro bono project, the types of cases you'll be seeing. But let's get into eligibility now. And we'll get into, again, more detail about the specific disabilities a later part of this presentation. So when we talk about eligibility, we're going to talk briefly about some distinctions between federal and state definitions. So the question is, who's a veteran? If you guys were all in person, if we were in person right now, I'd say, raise your hand. Who here knows what a veteran is? Give me a definition. And you'll hear several definitions pop up across the room. It's actually how I start off most of my clinic classes as well. Day one, who's a veteran and why? Tell me. So that's their work before the clinic starts. And you'll get a bunch of different answers. And depending on who you ask, the definition of a veteran changes. And this is very important. It's not as simple as who's a veteran? No, somebody who served. The law's got distinctions and it's got rules. So let's get into them. If we look at Title 38 of the US Code, the governing law here, 101 subsection 2 lists a veteran, or defines a veteran as a person who served in active military, naval, or air service, and who is discharged or released under conditions other than dishonorable. I highlighted or emphasized conditions other than dishonorable here, and you'll see why. I pulled also, this is actually a typo. It's not from the Florida Constitution, my bad, but it's from Florida definitions in the statutes 101 subsection 14. Definition of a veteran is a person who served in active military, naval, or air service, seems pretty similar, and who was discharged or released under honorable conditions only, or who later received an upgraded discharge under honorable conditions, notwithstanding any actions by the U.S. Department of Veterans Affairs on individuals discharged or released with other than honorable discharges. So what did Florida say here? Florida said, yeah, we're kind of like the federal definition, but harder, more exclusive. And also, you could be a veteran under the federal definition, but not here in Florida. So the Florida definition is one of the most exclusive definitions of veteran that you'll find in states' statutes. But we'll talk a little bit more about why that matters. Now, the one thing I do want to point out here is when we talk about a couple of things, we have under conditions other than dishonorable this is the federal definition. And then when we look at Florida, we have under honorable conditions only. So if this is the first time you're doing anything with VA benefits or military and you have no knowledge of any of this stuff prior, you may think, well, don't those mean the same thing? Other conditions other than dishonorable and honorable? Like, isn't it just honorable and dishonorable? Well, we're going to get into that in just a little bit. Another part of the Florida definition, not to harp on Florida too badly, another part of the Florida definition that is especially damning is the second part. So there's three different parts of the Florida definition. So this part, under honorable conditions only, is important. The second part, and it's the third part that's actually most damning. The second part is if you received an upgraded discharge. So Christie's program handles discharge upgrades. If the military changed your character of service to under honorable conditions at some point, then you're considered a veteran under Florida. However, notwithstanding any action by the Department of Veterans Affairs for individuals with other than honorable discharges, meaning you could have an other than honorable discharge, meet the definition of other than dishonorable, because other than honorable and other than dishonorable are not the same thing. But under the Florida definition, even though the VA found you other than found you to have found you to have a discharge that was under conditions other than dishonorable, even though the VA found you there, you may not be a veteran under Florida definition. So that can impact certain things that we're going to talk about right now. So why does that matter? When we talk about the federal definition, we looked at the statute. Here are the regulations. 38 CFR 3.1. This governs the Department of Veterans Affairs under conditions other than dishonorable. It's determined by the VA through a process called Character of Service Determination, CSD. You'll hear people say it's COD, administrative decision. There's a bunch of different names for it that we'll get into. And this process is separate from a discharge upgrade, which we do discuss very briefly later on. But just know this is an administrative process through the VA where a veteran may come in with an other than honorable discharge. And the VA can say, well, based on the circumstances, which we'll talk about, they don't fall under the dishonorable side of things. More on that in a moment. And under Florida, 1.01, again, not part of the Constitution, just part of the definitions in the statutes, subsection 14. It only takes into consideration, really, the veteran's discharge document, their DD Form 214, their Department of Defense Form 214, which we'll get into more detail about that in like 2 slides from now. They don't care what the VA's determined. They only care about what the military says. So whether it's their initial discharge document through the DD 214, or it's an amended discharge document, maybe an amended 214 or a DD 215, that's what Florida cares about. What is on the actual discharge document. Now, implications here used to include Veterans Treatment Court. In Florida, it doesn't include Veterans Treatment Court anymore because Florida's opened up its eligibility in Veterans Treatment Court to veterans, not just that those who fit the definition under 1.0114, but to pretty much anyone who has ever put on a uniform. Some state education benefits, some other state specific programs, some tax benefits are going to be have some issues with that may have some tension here. So you could be a veteran under VA definition, be getting service-connected disability, be getting healthcare at a local VA facility, but you're not a veteran under the state that you're living in, the state law that you're living in. Kind of weird. Another issue that can come up is, let's say you commute between states, you live on a border of 2 states. You could be a veteran in one state, but not in the other state, according to their own state laws. If I could have it my way, we would just use one definition of veteran, but that's another conversation to have at a later date. So yeah, just keep that in mind, that know your state's definition of veteran, see how it differs. It's mostly going to differ in this language under conditions other than dishonorable or under honorable conditions only. That's where we see most of the differences throughout the states. Now, why does this matter? Let's focus on the federal definition and figure out why this matters and what we need to think about. Now, again, this definition applies to veterans who are seeking all benefits available under VA, except those that may otherwise be allowable under different regulations. For example, so we operate at United Way Broward through Mission United, SSVF program. Many of you are familiar with SSVF and probably work with or in an SSVF program. It's Supportive Services for Veteran Families program, or maybe Grant and Per Diem program, which we operate as well, or a HUD-VASH program, which is the Housing and Urban Development and VA Veteran Assisted Supportive Housing program that exists. All of those programs use a different definition of veteran. And they allow homeless veterans or veterans who may be experiencing homelessness to access these services. So many of the homeless service providers are able to serve veterans who may not fit this definition. So another thing I want to make sure you understand is this specifically applies to those folks seeking benefits under disability, for disability benefits, not those seeking benefits under homeless service programs like SSVF, HUD-VASH, or GPD. They have a broader definition of veteran that does allow for some more leeway in their discharge status. So let's go back to our disability talk. Veterans coming in, wanting to apply for service-connected disability benefits. We're having an initial conversation with them, and a couple things we want to figure out. So if we look up at our definition in orange up here, we're trying to figure out, are they a person who served in the active military, naval, or air service and who is discharged or released under conditions other than dishonorable? Well, let's find out. So we need to know a few things. What capacity did they serve? What was their character of service? What was the narrative reason for separation? What type of discharge did they get? Did they retire? Was it medical retirement? Did they age out? What happened? How long did they serve? Did they have previous enlistment terms? These are just some of the questions that kind of go through your head when you're initially meeting your client for the first time. So how do we know that? Oh, this is so many questions we have to ask. Well, don't worry about it. They have a document for this stuff. This is a snippet. Oh, well, actually, I have one right here. This is a full, still snippet. This is a snippet of a DD-214. It's the first section. We're going to break this down into kind of three parts of a DD-214. So if you look at the DD-214, it's got a lot of information on it. It's got the biographical information, dates of service, awards and medals, training, rank at separation, separation code, our two terms of art, narrative reason for separation and character of service, and it's got a reentry code. And we're going to get into this right now. So these are the two different sections that we're going to look at of the DD-214. We'll start with this one. And here what I want to point out is it's redacted. This DD-214 is redacted because it's got some very personally identifying information on it. And so what I want to do is we'll zoom in a little bit here. And you'll see that on the top left, it has their name, first and last name, first name, middle. And this is a real DD-214 for one of my clients. This has their department or component or branch. This is Army. RA means regular Army. They have their social security number blanked out, of course, here for us. And on the real actual document, it's not blanked out. It's there. But for the purposes of not doxing my client or getting all their information out there on the internet, this is what we're doing. They have their rank and pay grade at the time of separation on here. They have their date of birth fully written out, any reserve obligation, when that would end. You'll be able to see if they still have reserve time, where they went into active duty, where the home address was at the time, where their last duty station was, where were they when they were separated, which command they were in. So this top information, this top box is really useful for for figuring out, who your client is, confirming who they are, who they say they are. And obviously, you'll want to make sure that they can produce a form of government ID as well, and not just the DD-214. You want to make sure that this person is actually who they're saying they are. The second part that I want to talk about is this middle section. So this middle section has some more information about who they were in the military, what they did. So we're going to take a look at some of these things here. First, we have their box 11 over here has their primary specialty. This is an Army veteran, so we have MOS, or military occupation specialty. And our guy here, or girl, our guy here has a 91 Bravo, 91 B10. He was a wheeled vehicle mechanic, 91 Bravo, 4 years, 3 months. That's all he did in the military, 91 Bravo. Knowing, or really asking the question about what you did in the military is a great way to kind of start building rapport with your client as well. So the first time you're meeting one of your clients, you're an attorney, they're probably nervous talking to you, or anxious, or just annoyed. And a good way to kind of break the ice when you're talking to them is, hey, what'd you do in the military? What was your MOS? Assuming that they're not Air Force. Air Force doesn't use the term MOS, but you could still say it and they'll think it's cute. Ask them, what'd you do in the military? What was your job? Obviously, if they're Army or Navy or Marines, you can say, what was your MOS? And most of the time they'll say, oh, 91 Bravo. It's okay if you say 91 Bravo, what was that? And they'll go, oh, wheeled vehicle mechanic. And you're like, oh, cool, man. And it's a good way to start a conversation about that. And then, kind of start thinking about what you may be wanting to look for when you're talking to this client. Just like any other initial conversation you're having with a client, you're going to be doing issue spotting. And a DD-214 is a great way to start issue spotting. And we'll talk about how we do that in a second. On the right side here, we have their record of service. It's written a little wonky, but bear with me and you'll be an expert in no time. So there's a few different boxes here. Starting with the top one, we have the date that they entered AD this period. That's a date entered active duty this period. And here we have 2007, 9, 13. So that's September 13th, 2007. When were they separated during this period? Whatever is on this DD-214, we have 2012, 8, 10. So that's August 10th, 2012. Now, you don't need to get out your calculator or your calendar to figure it out because they have the net active service this period, 4 years, 10 months, 28 days. Another thing, a lot of service members, they get out they look at their DD-214 once, they go, cool, they throw it in a drawer. It's not until somebody like us asks them to bring in their DD-214 that they ever really look at it again most of the time. So another good way to kind of build rapport as well is when you're looking at a DD-214 prior to talking to your client, you ask them what their MOS was, you start talking there, and you say, man, you're in for 4 years, 10 months, and 28 days. I'm like, wow, they're like, you're really astute to detail. It's like, well, it's low hanging fruit. It's right here, 4, 10, 28. If they had any active service prior to this enlistment term that's listed on this DD-214, it'll be here, or any inactive service or reserve time or otherwise, it'll be here. This veteran did not. Now, foreign service, let's move down to foreign service. This lists, when I see this, 1, 11, 14, that's 1 year, 11 months, and 14 days of foreign service. We'll get to that in just a second. Sea service, how much of that time was on sea? This individual had none. Initial entry training, this was 7 months and 16 days of initial entry training. An effective day of pay grade, 4/5/2012. So that was when did they, the pay grade that you're seeing up here in box 4A and 4B, when did that get established? So without looking at anything so far, let's take a step back and say that this is the first time we met our client, and we know they're in the Army. We know their date of birth. We know they entered in 2007. We know he was a vehicle mechanic, wheeled vehicle mechanic. I see an INF here, usually means something about infantry. So what can I kind of assume here? All right, well, there's a couple things I think about already. They were from 2007 to 2012. We're still pretty involved in the overseas conflicts in Afghanistan. So this foreign service of 1 year, 11 months, and 14 days, I'm thinking might be a couple deployments to Afghanistan. Another thing that popped out right away is this person served 4 years, 10 months, and 28 days in the Army. But their rank is private first class, and they're an E1. That's the lowest pay grade you can have. So that means something happened. Obviously, you're not entering as an E1 and staying in E1 for 4 years, 10 months, and 28 days. So it makes me think, okay, something happened that their rank, they got busted down, that their rank got their rank got lowered. All right, so it's a couple things I just noticed right away looking here. So let's go scroll down here and go to the next section. This is box 13. And this is decorations, medals, badges, citations, campaign ribbons, awards, all the stuff that you would see on a military jacket. And we can see Afghan campaign medal with 3 campaigns started. Okay, that means we have a multiple service in Afghanistan. Oh, next one here, we see Purple Heart. That means this individual was injured during combat. We have a National Defense Service Medal, Global War and Terrorism Service Medal, Army Service Ribbon, Overseas Service Ribbon, second award, NATO Medal, Combat Action Badge, Sharpshooter Marksman Badge, and it continues on here in box 18 as well, which we'll get to in just a second. So we see, okay, yeah, we've confirmed, yeah, we've got a Global War and Terrorism, Afghanistan campaign. Yeah, we see he's been overseas. There's some training, military education here in box 14. Box 15 talks about any additional specific things that don't really matter to us right now. 16 would talk about any days of accrued leave that were paid to him. Again, none of the boxes 15, 16, 17 don't really apply too much to us right now, though it's important to note that they exist. Box 18 is an overflow pretty much. So here we have a few things that were added. So this is from up from block 6. So here is up from reserve obligation termination date. We have a period of a delayed entry program, meaning he probably enlisted before he was, I don't know, 18, or maybe he enlisted while he was still in high school, or maybe he enlisted and didn't quite go in yet. There could be several reasons. Here we have he served in a designated imminent pay, a danger pay area, meaning yes, he was deployed to a combat zone. Here we can confirm the dates now. Service in Afghanistan. We have January 1st, 2009 to January 9th, 2010. So just over a year in Afghanistan the first time. And then we have a second deployment to Afghanistan. We have April 1st, 2011 to March 5th, 2012. So another 9 months in Afghanistan there. equals close to 2 years. So we saw his foreign service up here, where it said 1 year, 11 months, and 14 days. That's the foreign service. 2 combat deployments, 2 deployments to Afghanistan. Now we start seeing some things here that you might need an eye of doing this at least once before to notice, but member has not completed first full term of service. Well, since the 1980s, they've had some pretty standard enlistment terms of 4 years active, a couple of years reserve. So he served 4 years, 10 months, and 28 days. What happened here? Why does it say that? I don't know, but it makes me think something must have happened. And then again, from block 13, some additional decorations that this individual had, in addition to all these ribbons that and badges and medals. Here's some additional things that he accomplished as well. So we know a lot about the veteran just based on this DD-214. Let's talk about the bottom part of the DD-214. Specifically that which is found on the member 4 of the DD-214. Now, you may get a copy of a veteran's DD-214 that just looks like this, and that's all you see, and you're like, oh, cool, this is a lot of information, but it's not enough information. You need to make sure you're getting a member 4 or at least, or whatever other copy of the DD-214 that will include this bottom section of special additional information. Now, all of this information is very important here, and this is where we see our terms of art, where we understand how or why this individual was discharged. This is from the same DD-214. So we have the type of separation, discharge. Yes, he was discharged from the military. Pretty normal to see up there. Character of service, we have under other than honorable conditions. So other than honorable discharge, or OTH. We have the separation authority. If you looked up the Army Regulations 635-200, paragraph 14-12C, you'll see exactly what it says, but it probably says the same thing that it says in box 28, which we'll get to in a second. Same with the separation code and reentry code. Reentry code 4, practitioners, when they see that, they go, well, this must have been something bad. And RE4 pretty much means that you're not getting back into the military once you get out. And same with the separation code JKQ, also has specific meaning to it as well. But we can essentially see, when we look at the narrative reason for separation, we see misconduct, a serious offense. So we can assume right away that this individual, presume, pretty not even assume, but presume right away that this individual was discharged from the military under other than honorable conditions for a serious offense, for misconduct that was a serious offense. We won't know exactly what that is based off the DD-214, but we will know that it was serious enough that it required an individual with 2 combat deployments, Purple Heart, 4 years, 10 months, 28 days in the military to lose all of his rank and be kicked out of the military. So the interesting thing about this individual is that if you think about it, under both the federal definition and the Florida definition, until the VA were to make a determination, he is not considered a veteran. Let that sink in for a second. If I told you, hey, I know a buddy of mine served 5 years in the Army, went to Afghanistan twice, got a Purple Heart, you'd be like, that guy's a goddamn war hero. This individual was not considered to be a veteran under VA or Florida definition because of this DD-214. More to come on that a little later. I'll tell you a fun fact to kind of ruin everything and bring your spirits up a little bit. He is now considered a veteran under VA and Florida definition. So we're doing okay. But it took a very long time to get everything sorted out. But yeah, it was a client of mine from 2016, still a client of mine. So it's we're still working on ironing some kinks out, but it's one of these things where this area of law can have a huge impact. So let's talk about ways people can be discharged. So here's some common ways, not every single way, but some common ways. We have the ETS, or expiration of term of service, or ESA, it's the expiration of the service agreement. That's the most common way that service members are discharged from the military. And the overwhelming majority of veterans you meet were ETS. They were just done with their contractual obligation. We also have an administrative separation, sometimes called ADSEP. I'll probably say ADSEP a few times, or ADSEPT a few times. And that's the separation prior to their ETS through a separation board. It usually results in a less than honorable discharge, and we'll talk about what those options can be, what's on that menu in just a moment. Not always, but it usually results in some sort of less than honorable discharge. It is just a way to get someone out of the military prior to their ETS date for a multitude of UCMJ or Uniform Code of Military Justice violations. And we'll talk in more detail about that in a moment. They could be discharged due to court-martial, which is a punitive result. It's tried through a military tribunal, results in a criminal record. It could have some confinement involved to it, other serious, long-lasting punishment. We'll get into that in just a moment too. Maybe they were discharged due to disability. So if a veteran develops a disability that prevents them from being unable to perform regular military duties, they may receive a disability type discharge or military retirement. Or maybe just retirement from sticking around long enough. So after 20 years of service, they may retire due to being done for 20 years, or like I mentioned too, they may have retired due to a disability too. And we're not going to go into it today because it's not necessarily relevant to the scope of this presentation, but there are some other benefits through the Department of Defense that are tied to disability and tied to retirement. So let's take a deeper dive on this bottom part of the DD-214 and talk about characters of service. And let's hark back to our definition of from the federal definition, under conditions other than dishonorable. Well, what does that mean? What are conditions other than dishonorable? So first, let's ask the question of what are the types of discharges a veteran can receive? Technically, on a modern day DD-214, there's really only 6 different things that can be written there, technically 7, but mostly 6 things that can be written there under character of service. And they're all here, color-coded for your enjoyment. The first one, an honorable discharge. The majority of veterans receive an honorable discharge. Great. That just means you honorably served in your period of service. That's listed on this DD-214. One other thing I want to point out, a DD-214 could have 1 or more periods of service listed on it. So just know that if you're seeing like 8, 12, 16, 20 years on a DD-214, assume that they had, 4 or multiple enlistments that were concurrent that are being shown on one DD-214. But if someone maybe served for a little bit in the Army, left, and then came back and reenlisted, whether it's in the Army or another branch, they may have multiple DD-214s. If there's any break in service, there may be multiple DD-214s. And each of them will have a character of service. Most commonly, it's just going to be one DD-214 with all the consecutive and concurrent enlistments on there. Now, again, honorable. Then we have general under honorable conditions, which is all, it's in green, which means it must be good. We'll talk about all of that in a moment. Next, we have other than honorable. Yellow is not the right color for it because it's bad. It's the worst type of administrative discharge you can get, but just know that's something that can be on there. It's not good at all. Then we have bad conduct and we have dishonorable. Those are 2 punitive discharges. We'll talk about that in a moment. And we have uncharacterized. An uncharacterized discharge might be entry-level separation. It could be a void enlistment. It could be dropped for the rolls. It could say something like fraudulent enlistment. There could be multiple reasons why someone has an uncharacterized discharge. But just know an uncharacterized discharge is not necessarily a bad or a negative discharge. It certainly could be, but it doesn't necessarily mean that it's a bad discharge if you see uncharacterized. Now, it's color-coded to make it as simple as possible, but of course, there's going to be more complexity to it. And let's get into it a little bit. So generally speaking, an honorable and general discharge, and let's go back for a second, general under honorable conditions, I'm going to call it a general discharge, probably for the rest of this presentation, because general under honorable conditions is too much of a mouthful for me. So an honorable and general discharges, generally speaking, will allow for most VA benefits. And by most VA benefits, I mean VA disability-related benefits. When we're talking about education benefits, there are going to be some limitations for education benefits, for a GI Bill, for example, for veterans with a general discharge that may only be available to veterans with an honorable discharge. Now, other than honorable, That's going to generally be a bar to compensable benefits. When you see it right away, we'll get into all the gritty details in just a few slides. But generally, it's going to be a bar to compensable benefits, but may allow access to healthcare or healthcare for service-related disabilities. Ultimately, it's going to require an administrative decision. We're going to spend a lot of time after the break getting into what that looks like and what when an other than honorable discharge is a bar and when it's not. So don't worry. Just know when you see other than honorable discharge, there's going to be something that has to be done before the veteran can access benefits. Next, we have bad conduct and dishonorable discharge. As I mentioned, those are punitive discharges that are those are sentences as a result of court-martial. And then we have an uncharacterized discharge. If you look at the federal regulations, 38 CFR 3.12 K1, it does it generally equals conditions other than dishonorable. So for the purposes of the definition, uncharacterized, for the most part, with some exceptions, means that it's meets the conditions of other than dishonorable. And what we're going to do here, we're going to finish out the definition in just a moment. Actually, let's get through this. We have 2 more slides and then we'll take our break. Sorry about that. We have length of service. 38 CFR 3.12a does establish a minimum amount of active duty that's needed to qualify for VA benefits. And it's 24 months of continuous active duty, or a full period for which a person was called or ordered to active duty for reservists. And that applies for everyone who is served, anyone who enlisted after September 7th, 1980, or anyone who entered active duty after October 16th, 1981. And that's really because that's when they started having more structured enlistment terms of 4 years. So 24 months of continuous active duty service for enlisted service members is what's needed as length of service, though there are exceptions to length of service. So we don't really talk about it too much because one of the big exceptions is anyone with a compensable service-connected disability will get an exception for length of service. So if you don't have 24 consecutive months of service, but you have a service-connected disability, which is the thing you're applying for, they can waive that 24 consecutive months. So you could only have served 18 months, 12 months, 6 months, 1 month. But if you have a service-connected disability, which we'll get into what that means, we talked about those 3 elements. But if you have a service-connected disability, then you will not have to worry about having 24 consecutive months. We're going to take a break now. Take a little, I think 5 minutes should be enough. Is that good? A little 5-minute break, Jorge?
Yeah, sounds good. We'll see everybody back at 2:13. There's a few questions in the chat that I've been trying to answer, but I'll get back to you. We can probably leave those questions towards closer to the end. So I'll make sure we address them and not miss out.
Awesome.
All right, see everybody back at 2:13. You can stay here in the webinar. We'll see you in 5 minutes.
Got a question to scroll back 2 slides. Yes, I'll scroll back 2 slides. This one.
So James, since I have you still here, there's a question in the Q&A. Does the length of service exception apply to pension as well? So it's there, right there in the slide. So I figured, I don't know if Manny, I don't know if you're there, but
So the VA pension itself has separate eligibility requirements, but yeah, essentially they're always all right. So one of the things to remember about 24 consecutive months is it only applies for veterans after 1980 and 1981. Prior to that, there was a different standard, and it was essentially, it's similar to the reservist standard. You can look it up in the regs. But yeah, it would apply for veterans after 1980. But again, there's always exceptions to that rule.
All right, and Manny was there, so he did post here in the chat. Do you remember the location for that standard?
And
We're trying to
we'll get
track
to it
it
in a moment.
down. All right.
We'll get to VA pension in just a moment, and I'll have the regulation site on there.
All right, thank you.
No problem.
So it's 2:14. We'll likely be ready to get started pretty soon. So hold on, hold tight. We'll be right there. So James, if you're ready, feel free to continue.
Absolutely. For those keeping track, I have now decided to sit down for the second half, as the benefits of a standing desk are wonderful. All right. So welcome back, everybody. I want to tie up this section of eligibility with talking about our general rule and kind of what does it mean? How can we synthesize the 38 CFR 3.12 and 3.12a to come up with one easy to digest rule of, who is a veteran? So under this guidance of Title 38, we really have a person who served in the active military, naval, or air service and was discharged or released under conditions other than dishonorable. So generally, that's the rule. So generally, the veteran must have 2 years of honorable service as determined by the VA, or meet an exception if their honorable service was for fewer than 2 years. So those are the two things to look at. Character of discharge. So unless the VA determines their discharge to be other than dishonorable, which means if they have an honorable discharge, if they have a general discharge, or if the VA has otherwise determined their discharge to be other than dishonorable, should be good. And length of service, unless they meet one of the exceptions under 3.12a subsection D. So those are the two things that we look at. Now, again, length of service, fairly straightforward to overcome. If I were to be screening someone for basic eligibility for VA benefits, and they came to me and they said, hey, I have an honorable discharge, and I really got hurt in service, but I was only in for 14 months, so I guess I don't qualify for VA benefits, right? And if all you knew was that, they had to meet 24 consecutive months, you'd be wrong, because they may meet an exception. So it's good to know that those exceptions exist. Likewise, if they were to come in and they said, I have an other than honorable discharge, am I eligible for VA benefits? And you straight up told them no, you may also be wrong there as well. So let's get into it of how we can overcome a negative eligibility determination. How can we overcome an other than honorable discharge? So this type of DD-214 is often called a bad paper, and the OTH is often called a bad paper discharge, at least used to be during the Vietnam era. It still sounds pretty cool, so sometimes we use that terminology. But figuring how do you overcome an OTH? Why is an OTH a bar to benefits? So we're going to talk about what constitutes a bar to benefits, and we'll dive a little bit into the insanity exception because it's a fun one. It's a little bit on slightly on the advanced side, but it's not too bad. So we'll talk about the insanity exception and also some other mitigating factors as well, and we'll get into that in just a moment. So, and other than honorable discharge, as we discussed, it's an administrative discharge that's processed through the chain of command in order to remove someone from service, usually due to misconduct or some violation of the Uniform Code of Military Justice, without going through the court-martial process. Now, it could also be, you can also get an other than honorable discharge due to the sentence of a court-martial. So it could also be in lieu of a court-martial. So maybe the military said, hey, we're going to court-martial you for this crime that you committed, this violation of the UCMJ, of the Uniform Code of Military Justice. We're going to court-martial you. But to save us time, I'm going to give you a chance to not get a dishonorable discharge. We're going to let you take an other than honorable discharge in lieu of court-martial. Something that can happen and has its own consequences that we'll discuss. They may have a hearing before a discharge review board while they're getting adcept. However, as you can imagine, they may waive this hearing. They often sign a release saying that, no, I waive a hearing. I just want to leave. I want to go home. Usually before the administrative separation process begins, this service member has already probably been stripped of rank, stripped of responsibility, of duty, of clearances, of their job. They're probably, depending on the level of their misconduct, probably not in the same unit anymore. If they are in the same unit, they're definitely not doing all the unit things together. They're probably on desk duty somewhere else on base, saying, hey, you go into this room and you're essentially in timeout until we figure out how to kick you out of the military. So you can imagine that individual at that point is like, well, you don't want me here. I don't want to be here. I just want to get out and go back to my home and family as quickly as possible. And that can cause issues. And the veteran will generally sign an acknowledgement of the consequences of receiving an administrative discharge, of an ADCEP, for receiving an other than honorable discharge, which will include in that acknowledgement says, you understand that you will lose all VA benefits, which isn't necessarily true, but we'll talk about that in a moment. Now, the discharge process is often started at the suggestion of the command, and it occurs after some serious or repetitive misconduct that hasn't been rectified after rehabilitation and counseling. In the perfect world, they would say, well, hey, we've been trying to, we told you multiple times to stop doing this, stop showing up late, to, stop testing positive for marijuana or whatever it might be, but it's not working out for you. So we're gonna part our ways. And the command must follow procedural guidelines. However, it is a very, very subjective process. If you stick around doing this area of law long enough, and if you do discharge upgrades, you will certainly see or hear stories of a veteran saying something along the lines of, well, yeah, what happened was I came back from leave and they tested everyone in my unit, and I tested positive for marijuana one time, and they kicked me out of the military to make an example of me. You'll hear that. And then the next veteran you talk to be like, oh yeah, I tested positive for marijuana 3 times and I still got an honorable discharge. You may hear things like that because it can be very subjective. It's not necessarily just the crime or the violation that was committed that will lead to your discharge. The other thing that you might see is, oh yeah, you'll hear something. Yeah, there was a bag in my barracks that had some drugs in it or had some paraphernalia in it, whatever it might be. It had some stolen gear from the PX, and they didn't know who it was. So all 3 of us got in trouble, but I'm the one who got discharged. The other 2 guys are still in. You might hear that as well. Maybe the other 2 guys had better stories than your guy did. I don't know. Maybe your client's a bad historian. I don't know. But know that it is a subjective process and can cause problems, the administrative separation processes. Now, how do we overcome an other than honorable discharge? It sounds pretty bad. It sounds like, it's certainly going to be a barrier to benefits, but how do we overcome it? So there's certainly ways that we can. And generally speaking, having an OTH written on your DD-214 is pretty bad. When a veteran walks into the VA and hands them or talks to somebody at the front desk, whether it's someone at eligibility or just one of the volunteers that they happen to walk into, and shows them their DD-214 and says, hey, I need help. They may be told right there on the site, sorry, you have an other than honorable discharge. We can't help you. That's not how things are supposed to work, but that is, it is common to occur. It still, unfortunately, happens quite too often. They'll walk into a VA healthcare facility and say, well, you have an OTH. Sorry, we can't help you here. The way it's supposed to work is before being formally denied benefits, healthcare facility is supposed to send that request to the Veterans Benefits Administration to figure out whether that OTH falls on the honorable or dishonorable purposes for VA, whether it constitutes an other than dishonorable discharge. Because other than honorable and other than dishonorable are not the same thing. So it's, is it dishonorable for VA purposes or is it other than dishonorable for VA purposes? Now, that administrative decision, that process that the VBA does can be triggered when a veteran without a clearly honorable discharge first applies for any benefits. It can be them walking to a VA healthcare facility, which obviously has its own issues to it. They may be turned away at the door. It could be them applying through one of those forms that we listed, the 526EZ or 527EZ. It could be them applying for VA home loan certification. It could be anything that they're interacting with the VA for an affirmative application. When they don't have an honorable or general discharge, it will trigger an administrative an administrative decision review. And during that process, the VA will review all of the veterans' records and review their military personnel file. It will gather a copy of their military personnel file and all their records and anything else the veteran may submit, and then make a determination of, does this other than honorable discharge constitute a bar to benefits? We'll talk about how that works out in just a moment. And then overcoming an other than honorable discharge, maybe you did it through an insanity exception. Maybe you did it through other compelling circumstances. We'll talk more about those 2 things in a moment. Prior to a few years ago, when they changed the regulations, the insanity exception was really the only way that you could overcome an OTH when there was a bar to benefits other than a discharge upgrade. It was at least the most common and frequently used one. But we'll talk about that now. The regs have changed slightly over the past couple of years. And then discharge upgrade, which again, shout out to Christie's program for really championing those throughout the state of Florida. Discharge upgrade is a process through the military branch and through individual boards through that military branch that will take a look. We're not going to go into the upgrades right now in any real context, but just understand it's another administrative type process governed by individual military branches where they will take a look at the veteran's military service, post-military service, and any other mitigating factors and compelling circumstances, to determine whether their discharge was proper or legally proper or equitably fair in light of all the evidence raised. So let's talk about why is it that an other than honorable discharge is not allowed. You can pour through Title 38, CFR 3.12 is the governing body for the stuff. So you can pull it up, look at 38 CFR 3.12C, look at 3.12D, read all of 3.12. You will not find anything in there that says an other than honorable discharge is a bar to benefits, because it's not. An other than honorable discharge by itself is not in the regulations or in the statute a bar to benefits on its own. Now, a punitive discharge, a bad conduct discharge, or a dishonorable discharge are, but an other than honorable discharge alone is not a bar to benefits, which means if your client has an other than honorable discharge, the VA has to tell you why it's a bar to benefits if they're denying benefits. So there's two different pools that your client can fall into for being barred from benefits. The first is found under 3.12C, and they're considered the statutory bars. There's 6 of them. There used to be 7 of them. I'm not going to go through the last one anymore because we don't have to worry about it anymore. So it doesn't exist. But there's 6 of them. For those who know what I'm talking about, you'll be like, yeah, we're glad we got rid of one of these bars. Anyway, 3.12C, here are the reasons. As a conscientious objector who refused to perform military duty or refused to wear the uniform, not very common. By reason of the sentence of a general court-martial. Yep, that happens. Those, like I said, maybe they said, hey, we're going to court-martial you. There's a few different types of court-martial. There's general, there's special, and there's my brain not working right now, court-martial. So there's 3 different types of court-martial. If it's a general court-martial, summary court-martial is the third one. If it's a general court-martial that they're going to give your veteran, which is the harshest type of court-martial, and they say, instead of giving you this general court-martial and going through this process, that's the next one. If you go through the general court-martial process and you receive an other than honorable discharge, that is your bar to benefits because it was by reason of the sentence of a general court-martial. Maybe it was resignation by an officer for the good of service. So as a commissioned officer, you were asked to resign. That can be a bar to benefits. Maybe you were labeled as a deserter. That usually means you had long periods of AWOL or unauthorized absence that resulted in you ghosting the military long enough that they marked you as a deserter. Deserter status can usually be overcome by turning yourself in. As an alien during a period of hostilities who requests their own discharge, that was exclusively for the Korean War. And then the last one is AWOL for more than 180 days unless there are compelling circumstances. And 3.12C lists out further compelling circumstances for AWOL, which I think we touch in just a moment. And now let's talk about regulatory bars. These are other reasons why an other than honorable discharge, for example, may be a bar to benefits. So all these reasons are considered to be reasons that would make your discharge under dishonorable conditions. And there's 4 of them here. We have acceptance of an undesirable discharge in lieu of general court-martial. So that's what I was kind of getting at the first time. Let's say they were like, hey, we're going to give you a general court-martial, but instead of going through the process, how about you just take this other than honorable discharge instead? Well, that will then be a regulatory bar to benefits. Mutiny or spying, not very common, but clearly a reason that you'd be barred from benefits. An offense involving moral turpitude. If you've done immigration law before, these are often called CIMTs, a crime involving moral turpitude. Includes generally a conviction of a felony or other felonious action, unless there's compelling circumstances for that act. And the most common reason why a veteran may be barred from benefits is willful and persistent misconduct, absence of compelling circumstances. The regs were updated recently to include unless there are compelling circumstances, which makes life a little bit easier for us practitioners who are trying to establish eligibility for our clients, because prior to that, a lot of the time you would have to try to argue insanity or get a discharge upgrade. But this is willful and persistent misconduct are it's the most common reason why an other than honorable discharge would constitute a bar to benefits. Now, let's talk about that for a second, and we'll talk about willful and persistent. And willful meaning deliberate or intentional wrongdoing, and there's a knowledge component, and it needs to be willful. It doesn't require specific intent, but it certainly needs to be, willful misconduct. Persistent, on the other hand, what does persistent mean? It means you usually more than once in a time frame that makes it in a close enough time frame to show some sort of persistence. For example, 3 months in, service member punches a civilian in the face, and then 4 years later, service member gets in a fight, on base. Is that persistent? I don't know. It's a question of fact. So that's there has to be some level of persistence, but it certainly means it has to have happened more than once. There's an example I gave earlier where a veteran comes off leave, tests positive for marijuana because he was out having fun with his friends on his leave. And chain of command goes, we need to make an example out of this guy because we can't have all these sailors getting off the ship coming back high. So they kick him out and they make it public, and they give him an other than honorable discharge. Well, fun question. If that was his only misconduct, is that going to be a bar to benefits? I surely don't see anything in statutory bars or regulatory bars that says a single minor offense, it's definitely not an offense involving moral turpitude. A single minor offense of testing positive for marijuana would be a bar to any benefit. However, what ends up happening sometimes is the VA will come back and say, yep, willful and persistent misconduct, you're discharged for testing positive for marijuana after coming back from liberty. Thank you, have a good day. And they'll say that, maybe not the thank you, have a good day part, but it'll essentially say that in their administrative decision, which will cause problems. That's certainly an appealable issue. And we'll talk about when you can appeal it, but you can essentially appeal it at any time after it happens, whether it's within a year or whether it's 50 years later. You can certainly try to appeal that issue, and we'll talk more about that process later. But willful and persistent misconduct, we see it a lot, and there's a lot of misinformation. Just like veterans walking into a healthcare facility and saying, oh, well, I have an other than honorable discharge, and being told, well, sorry, we can't help you. I've seen it before where veterans walk into, none of our veteran service officers here in South Florida, but will walk into it and talk to a VSO, whether it's at a county level or DAV or state level veteran service officer, and say, oh, yeah, well, I got an other than honorable discharge for testing positive for marijuana. And they're told, oh, well, you can't get benefits for that. You have an other than honorable discharge. You need a discharge upgrade. And that's just not true. Because most of the time it's going to be a bar for willful and persistent misconduct. And absent that, and absent any of these other enumerated bars, statutory, regulatory bars, their other than honorable discharge will be found to fall on the good side of the eligibility. I had a veteran client of mine that we worked with, and it took quite a long time for him to get benefits. But when he finally did, he was a little confused about the process, because I explained to him, oh, this whole time you were technically eligible, but for some reason, this was years and years ago, for some reason the VA kept fighting that your one instance of misconduct was willful and persistent. Unfortunately, the Board of Veterans Appeals cleared it up, but it took about almost 2 years to sort it all out. So that was unfortunate for him, but he was able to get the benefits that he was entitled to. So just know that even if a veteran's presenting with an other than honorable discharge, you need to know more than just that it's an other than honorable discharge. You need to know why. Now, let's talk about this other factor, which is compelling circumstances. So how do we overcome, let's say there is willful and persistent misconduct. What are compelling circumstances? So this is a fairly new regulation, 3.12 subsection E lists out compelling circumstances. They talk about all the AWOL, prolonged AWOL, and misconduct compelling circumstances. So they're going to look at a couple things. And for anyone who's done a discharge upgrade before, this kind of rewriting of this regulation I feel like it has some discharge upgrade characteristics to it. But They look at service exclusive of the AWOL or exclusive of the misconduct. How is it characterized? Is it honest, faithful, meritorious? Was it a benefit to the nation? Well, how can you prove this stuff? What type of arguments can you make that your client was actually a good person and that this misconduct, their service, exclusive of this AWOL was good? What were the reasons for the AWOL or misconduct? And is there a substantive legal defense that exists under the Uniform Code of Military Justice that would have precluded the AWOL or misconduct conviction? That's a fun one. Please consult your UCMJ expert friends if you run into any of these issues, or just become a UCMJ expert yourself. And a little deeper dive here of what are some of those reasons where they talk about that they're going to look at. So if any of these things exist, or you can argue any of these things, you may be able to successfully argue that there are, so going back here, you may be able to argue that there are some compelling circumstances. So let's talk about these. So is there a mental or cognitive impairment at the time of the prolonged AWOL or misconduct, to include but not limited to a clinical diagnosis of PTSD or depression, bipolar disorder, schizophrenia, substance use disorder, attention deficit hyperactivity disorder, impulsive disorder, or cognitive disability? So did they have a mental health condition that maybe could be the reason for their misconduct or AWOL? Physical health, was that a problem, including physical trauma and any side effects of medication? Can you make an argument there? Now, remember, you're going to have to back these arguments up with medical evidence, obviously, and usually a doctor's nexus statement, or the VA will offer you one, which we'll talk about later. Combat-related or overseas-related hardship, sexual abuse or assault, whether it occurred in the military or not. Maybe they acted under duress or coercion or desperation. Maybe they're acting about a family obligation or a comparable obligation to a third party. Or also you got to take age, education, cultural background, and judgmental maturity into effect here. So certainly a lot of additional considerations that the VA has to review now, instead of what it used to just be, which was like, oh, well, you had persistent, willful and persistent misconduct, and it was both willful and persistent. It's a bar to benefits. And written into 3.12, it specifically says benefits cannot be paid unless the person was insane at the time of committing the offense. Now, fortunately, we can have all of these compelling circumstances that we can use to make these arguments. Let's say you do have a client that did test positive a couple times for marijuana use, or cocaine use, or heroin use, or whatever it was. They tested positive multiple times. So yes, it's willful and persistent misconduct. However, you also then found out that your client was the victim of sexual assault 2 months prior to them starting drug use. Well, guess what? You have a compelling circumstance here that you can use to mitigate the fact that, yes, it was willful and persistent misconduct, maybe, or at least it looked like it. But there are compelling circumstances. The use was masking the trauma, was masking the sexual assault that they experienced. And that's just one example. It may not even be that extreme. So just know, you'll get to use these to your advantage when you have a client who falls on the ineligible side for willful and persistent misconduct specifically. It's really great to use. Well, let's talk about what if none of these really exist? What if there's something worse going on? You can still use the insanity exception. 3.12 talks about insanity and how both the regs and the US Code mention that if a person was insane at the time of the offense that led to their court-martial or discharge or resignation, they shall not be precluded from benefits. So this means if they have going back a little bit, a statutory bar perhaps that doesn't allow you to get compelling circumstances involved, if they have a statutory bar, you have to whip out the insanity exception. Now, there's a lot of words here on the screen, and the insanity exception is a little bit complex for this seminar today, but I do want to make sure that you understand that it does exist, and that we are able to talk about a little bit about insanity. Now, I'll share this PowerPoint with you, so you'll have all this stuff. But just know, basically, it means that due to a mental health condition, the veteran or service member, more specifically, experienced a prolonged deviation from their normal method or behavior, or had behavior that interfered with the peace of society, or has, actually, I think I've written out here. Yes, perfect. Has departed from the acceptable standards of the community for which by birth and education he belongs, as to lack of adaptability to make further adjustment to the social customs of the community in which he resides. I love how the VA writes some stuff sometimes. Really just means that if you've got a couple of these elements here, you have to make sure that they both have or have had a diagnosable mental health condition at the time of or during the time that the misconduct existed, and that you can establish a baseline of who they were before. Meaning, like, you had someone who served for 5 years, and 4.5 of those years, perfectly upstanding individual, they were promoted. They maybe had some, extracurriculars. They used to help old ladies cross the street. They volunteered at their church, whatever it might be. But then something happens. Maybe it's, they get injured while on deployment, and they come back and something happens where they misbehave. They have misconduct. They act out. And then you find out, oh, well, they have a diagnosis of post-traumatic stress disorder. That is great grounds to then to think that the insanity exception may be something that can be pursued if you can't pursue an easier route to get them benefits. Again, the insanity exception used to be really the main way to get around some of these bars to benefits, but it's now used only when needed. One of the things that you are, one of the good things is that you don't need to show that the disability caused the misconduct through insanity, just that they existed at the same time. And there's an old VA General Counsel opinion from 1997 that talks about that as well. That you can kind of get around some of this stuff. And again, I'm not going to go too deep into it. Just know that it is an option, that if someone is found to be insane, that they cannot be barred to benefits based off of their insanity. I just went through a very long fight with the VA about a case with the insanity exception, where it took an additional 1.5 years for them to actually fix the case, because we were granted, our client was determined to be insane at the time of the commission of an offense, and then the VA just did nothing about it. It's not very common that happens, but as an advocate, you've got to stay on top of these cases. So it took an additional unacceptable amount of time to get the VA to correct their error. So fortunately, the veteran did receive retroactive pay for the 2 years that he had to wait, plus the additional time he had to wait, but still, that's 2 years that he went without benefits that he would have otherwise been entitled to. Let's talk a little bit now about, give me a second here. So when let's talk about how healthcare and other than honorable discharges work with each other. So most veterans that have an other than honorable discharge can still receive healthcare benefits for their service-connected disability. So even if they're barred from receiving compensable benefits due to one of those statutory regulatory bars, for the most part, they should still be able to receive healthcare services from the VA for those service-connected disability benefits. Now, they're not necessarily going to be allowed to go in and get all the healthcare benefits, but they very well may be able to go in and get some basic level of treatment for their service-connected disabilities. The VA still might give you grief for it, but push enough, if you can advocate for your client at the local VA hospital level, you'll usually get them to remain enrolled in some of these benefits. at least long enough while you sort out the rest of their discharge. Now, sometimes you've got to be careful. So make sure before you're fighting for your client to stay enrolled in VA healthcare that you really understand the implications of what happens if you lose a case, because it could result in them having to pay back healthcare costs of some healthcare. It could result in that. There's ways to get around it that I don't think we discuss here today, but just know healthcare and ineligibility, or especially with other than honorable discharges, there are ways to get medical care with an OTH. So we're going to move on from OTH right now. We're going to get into a deeper dive about VA benefits. Now, I think that there's a lot of opportunity here to really learn about sorry, I was just checking to see if there's any. Cool. There's really good opportunity now to get a good introduction to the most common types of VA benefits. We went over them briefly, but this is going to be a deeper dive into all of that. We'll get through a couple of them in the next 30 minutes and then take our next break. So let's get to it. So let's talk about the differences between compensation and pension benefits. So you often hear compensation, VA compensation and VA pension. So what does that mean? Well, VA compensation or disability compensation is more commonly known as service-connected disability. It's a benefit awarded due to an injury, disease, or condition that began or was aggravated while on active duty. So we call it service-connected disability for the purposes of this presentation. We also have VA pension, and that's the benefit that's awarded to low-income veterans who served during a wartime period and who are either disabled or over the age of 65. And again, not to be confused with military retirement pension. This is VA pension. Military retirement pension is a monetary benefit that individuals get for retiring from the military. It's paid out by the Department of Defense, and it's much different than VA pension, which is why I like to call it non-service connected disability. Now let's talk about service connection. Again, a bunch of words here, but we're going to get right to the point. This is directly from 38 CFR 3.303, which governs service-connected disability for the regs. And you can read it all. I'm not going to read it to you. I already read that underlined part. Essentially, a particular injury or disease resulting in disability was incurred coincident with service in the armed forces. What that means is you don't have to prove that it happened because of service in the armed forces, just incurred coincident with. So what is that? Let's dig a little deeper. Veteran suffering from a disability that incurred while on active duty or had a pre-existing condition that was aggravated while on active duty can be established through direct service connection or presumption, which we'll get into. VA considers a broad spectrum of evidence when considering these claims, fortunately. They will weigh evidence, obviously, based on its applicability and its reliability, but they will certainly accept anything that you have as evidence. And all evidence must be considered under broad and liberal interpretations in the light most favorable to the claimant, our veteran. So let's talk about the bare bones and get into the three elements of service connection. So we're going to start with direct service connection. And these are the three elements of direct service connection that more or less are used to frame all types of service-connected disability claims. So our brain, when we're talking to our clients and they're saying, I really want to apply for service-connected disabilities, or I want to apply for disability benefits for my back, or for my shoulder, or for my mental health conditions, or for whatever it might be, we are going to want to know a couple things first. One is, okay, well, what's up with your back? What's happening? Oh, well, I get this radiating pain from my mid back to my low back quite often. You know, it happens every so often, and it's really debilitating. Okay, well, have you been to a doctor? You want to ask questions. Have you been diagnosed with anything? If they might, oh no, I don't want to go to the doctor. I just deal with it. I take some aspirin. Okay, well, that's fine. It sounds like you got a diagnosable disability. You got some pain in there. You got symptoms of a disability. They don't necessarily need to get a diagnosis before pursuing service-connected disability claims. Talk about that in a moment. The second thing is, okay, well, tell me about, do you think it's related to your military service? Is there something that happened to you in the military? Yeah, there was one time I was rappelling off of a wall, and my rope slipped, and I fell 15 feet right on my back. And oh man, it hurt. I was laid up for a couple of weeks. It wasn't good. Okay, cool. That's really the basics. You'll need to probably be asking a lot more questions, but you've now kind of figured, okay, well, they've got a back problem that hurts them now. Something happened to them in service. It seems like they're starting to form the basis of a service-connected disability claim. Maybe they should go after applying for this. And the last one is medical evidence establishing a causal nexus, that the disability was at least as likely as not caused by the in-service event. So what does that mean? Well, we have to look at those two things. And so we need medical evidence that shows, in our example, that veteran's back condition was at least as likely as not caused by them falling 15 feet while slipping off the rope. It seems like that would be pretty easy, right? Well, it might not be that easy. You'll need to get a medical opinion. The VA will certainly provide you one if you meet the basic criteria to get a compensation and pension exam, but it may not be as easy as it looks. What happens sometimes in these claims, especially with the second thing, the record of an in-service injury, is one, maybe it was never recorded. Maybe you slipped off this rope, you hurt your back, and you got back up, took a bunch of Advil. You didn't want to be the sick hall ranger. So you got up, you took some Advil and you toughed it out, even though your back was killing you for weeks. And then when you got out of the military, you didn't write anything about it in your discharge because you pencil whipped it saying you were fine and you just want to go home. Well, guess what? Now there's no record of your in-service injury. So there's not going to be anything in your personnel file likely unless you were put on profile or you sought treatment or you marked that you were injured when you left the military during your exit exam. That will show that you had an in-service event. So those records are very important to have. That doesn't mean that they've reached the end of the road. There's, like I said, the VA will take any evidence that you give them, but you'll need to find good evidence elsewhere. Now, the medical evidence, like I mentioned, we'll talk about more how we can help establish that. It can be private doctor letter. Maybe they're going to a doctor getting treated for their back condition. Maybe that doctor's familiar with their military records, and that doctor can provide something called a nexus statement. And that nexus statement can say something like, yes, I've been treating Mr. Jones for 7 years as his chiropractor, as his back doctor, or whatever. During this time treating Mr. Jones, I've become familiar with his service in the Army from 1998 to 2008. And specifically about the incident that occurred on June 6th, 2000, when he was rappelling off of a wall and slipped and hurt his back. It is my opinion that it's at least as likely as not that his current back condition, more detail about that, is at least as likely as not related to the incident that occurred on that date. That's a great nexus letter. It establishes, grounds that this person knows what they're talking about, at least enough grounds that they know what they're talking about, that the VA may very well take that as strong evidence. Chances are the VA will still send the veteran to attend a compensation and pension exam through an independent medical examiner to get a second opinion as well. Now, not everyone's going to be able to get a nexus exam. Not everyone goes to a doctor that is that cool that will write them. They'll take their time to write such a nice nexus letter. So maybe they don't have a treating physician for that. Maybe they're just going to the VA, and the VA doctors aren't going to provide an opinion. They don't want to provide an opinion to you, despite whether they are obligated to or not. They don't want to provide a written opinion about this. So what happens is the veteran will have to do their best to establish these elements of the current diagnosable disability and something that happened in service. And the VA will look at it and determine whether they should be afforded a compensation and pension exam or not. There's a few cases, a few federal cases to look at, and feel free to, if you're ever doing this work and you run into an issue like this, McClendon is really the holding case for this. I'll pull up the site for it later for you guys. But it really establishes the elements of when a compensation and pension exam needs to be issued. And without going into all the details of that today, just know that it's a pretty low bar to get a compensation and pension exam issued. A lot of veterans view them as a waste of time. They're like, well, why am I going to this examination? I know I'm injured. I know this happened. Well, it may be the only time you're ever going to get medical opinion to establish your claim. One other point to note is that compensation and pension examination, the word examination is a bit of a misnomer. It's not an examination. The examiner is using a questionnaire form to answer specific questions that are given to them or asked of them by the VA, depending on the disability. And your client may think, well, I'm going in for an examination. They're going to really examine me. And then they go in and they get asked like 6 questions and they're told to leave. And they're like, what a waste of time. They didn't even touch me. How can they determine I have a back problem? They didn't even touch me. Well, that's the what happens in a CMP exam sometimes. So, you can always prep your clients to manage their expectations. So let's get into some more direct service connection here. There's under 3.304, there's a presumption of soundness, which means the veteran's presumed to be in sound condition when they went into the military, unless it's otherwise noticed in their enlistment documents. So that's very helpful for you, saying like, oh, well, unless otherwise noted, you didn't have this condition before, you're okay. Second is combat veterans may submit lay evidence of an injury or disease when no official records exist. So if you're saying your condition was the result of something that happened on deployment, well, guess what? It probably didn't make it to your military personnel file because you're too busy doing downrange deployment stuff that you didn't take the time to note it in the record. So you can use lay evidence, and it will actually be considered as direct evidence. And the VA will also consider additional circumstances for prisoners of war and their confinement. And also PTSD claims are afforded special consideration under Section F of 3.304. And before you ask what special considerations, they're right up here. So if your claim, if the first element of your service-connected claim is that your condition is post-traumatic stress disorder, specifically, not that your condition is unspecified stress disorder or bipolar disorder or general anxiety disorder or depression or anxiety, you have to have a diagnosis of PTSD. And if you do, then you may be afforded these additional considerations. So let's talk about them. The standard changes a little bit. So diagnosis of PTSD, you need an in-service stressor. So stressor is a term of art specifically tied to PTSD. It's the S part of PTSD, stress disorder. What was the stressor that caused it? And then you need credible evidence supporting that the in-service stressor occurred. You don't have to prove that the in-service stressor occurred. You just need credible evidence. Usually for these claims, you need to come pretty close to proving that the in-service event occurred. But when it's PTSD, you only need to use credible evidence supporting that the in-service stressor occurred. And that's very important when we come to issues of victims of military sexual trauma who may have not reported that the sexual assault occurred. So they could use other sorts of credible evidence to establish the claim. So let's talk about what service connection for PTSD can be established under certain exceptions. So we have here diagnosis of PTSD during service. It's a great way to get it. Veteran engaged in combat with the enemy and claims stressor is related to combat. Okay, great. Claim stressor is related to the veteran's fear of hostile military or terrorist activity, and such symptoms are confirmed to be related by a medical professional. So while they're getting diagnosed with PTSD, PTSD has many different axes that have to be confirmed prior to a diagnosis being handed out. And if one of the stressors that's confirmed then is this fear of hostile military or terrorist activity, then that could be enough. Claim stressors related to their experience as a POW, or PTSD claim is based on in-service personal assault, and additional evidence can be used to corroborate the veteran's account of the incident. That could certainly be sexual assault or personal assault that occurred while in service. So all of these things can be taken into consideration when the claim is for post-traumatic stress disorder. And it's very important to know this because if your client is diagnosed with PTSD, their claim to get connected becomes considerably easier. It's not a slam dunk. Just because you have a diagnosis of PTSD doesn't necessarily mean that it's going to be service connected, but just know that there are more considerations and more that can be done to get PTSD service connected. And it's just one of those things to keep in mind. And just a reminder to it has to be the diagnosis of PTSD. Another thing to point out is that all of these things are probably equally as common. So I think I've seen every single one of these in a PTSD claim or individually in PTSD claims. So just know that a lot of these things pop up. Actually, I don't think I've seen prisoner of war, but I've seen the other ones. Let's talk about aggravated service connection. So this falls still under the same basic framework of those elements, but this is when a pre-existing injury or disease is considered to have been aggravated by service, where there's an increase in the disability during service. So what we're looking for is that something unnatural caused worsening of a pre-existing condition. So you can get into the military if you had, hurt your leg at some point in your youth. You probably have to get a waiver, and you've got to make sure you disclose it, and you've got to go through a whole process with your recruiter, but you could still potentially get into the military with a pre-existing condition. Now, if that condition is worsened by something that occurred while on active duty, you can get aggravated service connection. Now, there's a couple things you have to look out for. I mentioned it can't be due to the natural progression of the disease, requires clear and unmistakable evidence to rebut the presumption of aggravation, meaning it happens sometimes. The VA goes, well, sure, you did have this condition before, but it only worsened because that's the natural progression. You suffered from migraines before, but your migraines they got worse because medical evidence shows that that's how the natural progression of migraines work. That's just an example. I'm not a medical doctor. I don't know if that's actually true, but it's certainly something that the VA may say. It doesn't allow for the connection for the usual effects of medical or surgical treatment either. So you've got to make sure that there's something that happened outside of natural progress or expected side effects that have worsened the condition. Secondary service connection. I think this is one of the most useful tools out there for service connection. Secondary service connection allows disabilities that are proximately related to be service connected. So proximately related to an existing service connected disability that allows them to be related without that disability, without the secondary disability being service connected itself. So what does that mean? Let's get a good example. Something that I saw frequently about 5 years ago, probably 6 or 7 years ago now, it was pre-pandemic. So about 6 or 7 years ago, we started seeing veterans come in with migraines and saying, I want to service connect my migraines. And we started saying, well, they've fought service connection, they've been denied. The VA's come back and said, yeah, you're not really pointing to anything in service that shows that caused your migraines. You didn't have migraines in service. So they were getting constantly denied. So I consulted some medical professionals and we started talking about things. And someone pointed me to some articles about how tinnitus can cause migraines. So we started asking questions to our veterans that came in with migraines. So when did your migraines begin? Oh, well, they began XYZ. Okay. And what are you currently service connected for? Oh, the most common service connected disability out there?
tinnitus. So they're saying, well, I'm service connected for tinnitus. Well, tell me, what happens when you have a tinnitus attack? Oh man, if I'm sitting around and the ringing gets real bad, it really makes my migraines unbearable. Okay, interesting. So what are we looking at now? Now we're looking at these migraines may be secondary to tinnitus. Their tinnitus is service connected. They've already established that the tinnitus was caused probably by constantly shooting off guns or being around loud equipment for 4+ years in the military without proper ear protection. And now they're telling you, yeah, when my tinnitus goes off and it gets bad, I get these really bad migraines that last for extended periods of time. And so now you're looking, oh wait, this sounds like secondary service connection. So we were able to be successful getting secondary service connection for some of those veterans where the facts fit for them. Now, obviously, not every veteran who comes in with migraines who is already service connected for tinnitus is going to get secondary service connection for those migraines. But if the evidence is there, it's a great way to get potentially secondary service connection. So the point is, it's always important to look at when someone's coming in, well, what is this? Is this condition connected to something that already exists that's service connected? I'll give you another real world example for secondary service connection, where let's say someone's service connected for a right leg injury. Part of that right leg injury causes them to favor their left leg. They put all their weight on their left leg, which has caused deterioration in their left knee. Well, that left knee probably never going to be direct service connected. Nothing happened in the military, but because of the right leg service connected disability causing them to put pressure on their left leg, if the medical opinions are there that said, yeah, that type of knee deterioration is at least as likely as not caused by them favoring it over their right leg, right there, secondary service connection is likely to be granted. So it's a very important tool to use as well, secondary service connection. Let's talk about presumptive service connection. Presumptive service connection is exactly like it sounds. Like most things under the law, there are presumptions to make things a little bit easier and more streamlined. I'm not going to go into all of the details about presumptive service connection today, but I'm probably going to go into too much anyway. So let's talk about it. With presumptive service connection, we have mostly disabilities and diseases that are aspects of service in places that veterans probably shouldn't have been sent to. So a lot of presumptive service connection are for tropical diseases. Maybe it's a chronic disease or prisoner of war related disease, but a lot of them are based around what they call tropical diseases or exposure to things like burn pits and Agent Orange and toxins that really, it's really difficult to show direct service connection for otherwise. So what the VA did, without having the government have to admit that they used Agent Orange on individuals, they set up presumptions. And they said, hey, listen, if you serve during a wartime, one of these wartime periods, so if you serve during these times in one of these locations, and you have one of these disabilities, we're going to presume it was from your military service. We're not going to admit that you got exposed to Agent Orange necessarily, but we're not going to say all that now. We're just going to presume that your condition that's listed in the presumptive class is service connected. So if you serve during a specific period in a specific place and have a specific disability, we're going to presume it's related to your military service. I'll give you a couple of examples. So we have Vietnam era. I think for the most part, people understand that Vietnam era, there's a lot of Agent Orange. Agent Orange was a thing. So there's presumption that if you served during Vietnam, either in country Vietnam, on an airbase, in certain parts of the Pacific Ocean, and you have current diagnosis of one of these disabilities, and the 2022 PACT Act expanded these, but something like hypertension or certain cancers or tumors, that you will be presumed that that condition is related to your military service. You don't have to go through the bells and whistles. You don't have to show medical nexus. You don't have to show an in-service event. You just have to meet the presumptive class. And those are the three elements, essentially, for most of these, exposure issues, is that you serve during a certain period in a certain location and you have a specific disability. So it's very useful mostly for two classes, though there are several other presumptions to look into and learn. The two main ones are veterans who served in country Vietnam or during the Vietnam War in Thailand or on certain other bases as well, or in deep water veteran cases, the Pacific Ocean cases. So the Vietnam era veterans and also post 9/11 Iraq and Afghanistan veterans who may have been exposed to burn pits are another big one. Veterans who served in Camp Lejeune during 1953, 1987. They may have been exposed to contaminants in the water and may be eligible class folks in a presumptive class. And again, this is all to get service-connected disability benefits. Specifically for Camp Lejeune as well, and I think it's coming up now with burn pits, we're going to start seeing more mass tort cases, which are through federal class action lawsuits that are separate from service connection. But this is just for service-connected disability benefits. There are presumptive classes for these types of exposure. And this is where we're going to take our next break. It is 3:12. If we can get back here at 3:17, and then we'll get home from there.
Perfect. I'll start the countdown. I'll let everybody know when it's 3:17.
Awesome.
I'll see you then. Thanks, James.
All right. Got about 45 minutes left of the presentation and still a little bit more to get through. So we're going to get started again. Back to the standing desk for the last part of this. So once a service-connected disability is granted, then they go on to rating. So let's talk about rating. So the VA rates service-connected disability on 0 to 100% in increments of 10 based on something called Book C, a schedule of ratings disability. So every condition falls into one of these categories in the schedule of ratings. And in the schedule of ratings, it will show what the disability is and how it rates. Maybe it rates 0, 10, 30, 50, 70, 100. Maybe it only rates 0 or 10. Maybe it rates 0 to 110% increments. It depends on the disability. But to know, you have to consult the schedule of ratings. The schedule of ratings also explicitly details out what the disability would look like what the details of that rating look like. And they use specific language, and it's mostly based on severity and severity and frequency of symptoms, to put it simply. So the more severe, more frequent the symptoms are, the higher the disability will rate. Generally speaking, there's so much nuance to disability rating, but just know some disabilities rate all the way up to 100. Some disabilities only rate up to 10%. Some fall somewhere in between, but it's all increments of 10. Ratings can fluctuate based on the severity of the symptoms that the person is currently experiencing. So ratings happen based off of current level of disability, meaning you jumped out of an airplane in the Army, you broke both of your legs, and you couldn't walk for 8 months, and now you're able to run a marathon. You might get service connection for some residual damage to those legs, but they're not going to rate you as though for how bad it was when you were in the military. It's based off current symptoms and current rating of how bad the disability is right now today. Now, my example is a little far-fetched and exaggerated, but you get the point. There are some protections for ratings here. Rating cannot be reduced after 20 years of continuous rating unless fraud is shown. There's also protections for ratings that are 10 years or more from being severed, absent finding a fraud or ineligibility, meaning after 20 years, they can't even reduce it. After 10 years, they can't remove it from being service-connected. And after 5 years, the rating can't be reduced unless the VA has documentation. So the VA can't just blindly propose. They have to say, hey, we have this documentation supporting some sort of permanent improvement in your condition to warrant a reduction after 5 years. Before 5 years, the VA can at any time just be like, hey, we're checking out this other thing that you did, and we decide it's time for you to attend another compensation and pension exam because we think your condition might have improved. So attend a CMP exam so that we can determine if you're properly rated right now. And if you don't attend it, we're going to assume your condition got better and reduce all your benefits. So ratings are they can be fickle, but it's very important that your client, once they are service connected, and any veterans out there, once you're service connected, it's very important that you maintain your service connection by going to the doctor regularly for your conditions. And I don't mean you have to go every week, but you have to go as frequently as your disability necessitates. Meaning, if you only have to go once a year for a checkup because that's what your disability entails, then do that. But if you're supposed to be going to monthly therapy appointments or bi-monthly or weekly therapy appointments, you got to continue to do those. Because what happens is the VA can, especially within those first 5 years and even after, can say, hey, you used to have to come in here every week for physical therapy, but you haven't been to a VA facility in 8 months. So we're going to say that your condition has improved, show us otherwise, and they can propose to lower your rating. Now, why is the rating important? The rating is important is because it's explicitly tied to the amount of money that's paid per month for the disability. There's a link here, and you can just type in VA disability payment amount, and this is all from the VA's website from 2024. I think it's been updated now for 25. So excuse me on not updating this, but you can just go online and see. But you'll look, 10% pays $175.51 per month. For just a veteran without dependents. A veteran with dependents who's married will get paid more. But it goes all the way up to 100%, which is just over $3,800 a month untaxed for a single veteran without dependents who's 100% service connected. Now, 100% service connection can mean a lot of things. It doesn't necessarily mean that the person is completely disabled. There's plenty of veterans among us that are 100%, and you would never know it. It's just that's how their ratings and the severity of their symptoms add up. Now we'll talk about VA math in just a second, but as again, a veteran can apply for a ratings increase if they think that the severity of their current conditions warrant it. So once they're adjudicated service connected, at any time they can request to have their condition reviewed or their rating reviewed. I advise all of my clients that, or any veteran I talk to, honestly, that says, hey, man, I want to apply for an increase. Well, why? Why do you want to apply for an increase? If your answer is anything other than, while my condition is getting worse, I'm going to tell you, do not apply for your increase, because that's the only reason why you should be applying for an increase, is because the symptoms, the severity, the frequency of your symptoms of your service-connected disability is worsening, or and then if the answer is, well, I think my condition is getting worse, have you talked to your doctor about this? Yeah, my doctor agrees. Great. Well, if your doctor agrees, that means that are they willing to write a nexus letter? Probably not. But if not, at least you're going to have some sort of medical evidence in your treatment records to back it up, so that when you apply for that increase, the VA will go in. They'll probably still issue a compensation and pension exam, but they'll have the C&P exam and your continuing medical records to go off of. So at least, the worst case scenario that we try to mitigate here is, if a veteran applies for an increase, we want the worst case scenario to be that their disability rating stays the same. We don't want them to apply for an increase and then the VA comes back and proposes a decrease in rating, because now you're having to fight all that stuff. So you got to be very careful with it. Now, a reevaluation can be triggered really by several different things. As I said, it can be different applications for benefits, a lot of different interactions, weird interactions with the VA could potentially trigger a readjudication or a reevaluation of benefits. Not saying that they always do. However, the VA does give the veteran about 60 days to dispute the proposal. If they are proposing to reduce or remove their rating, they're proposing to change their disability rating, the veteran has 60 days. If they do it within the first 30 days, however, of the date of that decision letter or the proposal letter, the VA will continue to pay them at their current rate until the case is fully resolved. So as a practitioner, you have two deadlines. You have to file something within 60 days to dispute the proposal. Otherwise, the proposal becomes final. But if it's disputed within 30 days, then that veteran can keep their disability rating the same while pending the outcome. Now, if you wait 60 days and you end up, losing the case, but there could be other financial implications to this. We're not going to get into this today, but just know there are two deadlines. Let's talk about VA math or their combined ratings table. The VA does not use cumulative math, so 60% and 40% doesn't. If you have a disability rate at 60%, a disability rate at 40%, it doesn't give you a 100% rating. It actually gives you an 80%. You might say, James, why does that happen? The math is actually not too crazy to think about, but I'm not going to go through it. There is on the link here, you can also just Google it, VA compensation ratings calculator. A couple prominent law firms out there have some pretty good ones on their websites as well. It's a great way to drive business to your website, is have something useful on your website, including one of these. So check out a law firm website or the VA's website itself that has a benefits calculator, and you can play around with it to see what that means. In fact, you could have a 60 and 40 and then like 5 10s, and you're probably not even at 100% because of the way the math works. So it's not cumulative math. You'll have clients that come to you, yeah, I should be at 100%. I've got a 60, a 40, a 20, a 30. I'm 150% service connected. And you're like, well, you're not. You have quite a few service connected disability ratings, and you can show them the calculator and show them that. Now, there's another way to get rated to 100%, and it's called TDIU, or total disability and individual unemployability. VA is making up words with unemployability, but that's fine. We'll give them that grace to do so. So what's TDIU? TDIU exists when there is a disability that renders it impossible, service-connected disability renders it impossible for the individual to obtain substantially gainful employment. Social Security disability lawyers who are watching this right now, raise your hand, pat yourself on the back. I know that word. It is a very similar standard. The regs are mirrored. The VA regs are very similar to the Social Security regs on this for what substantial gainful employment is. TDIU sounds a lot like SSDI when it comes to eligibility and maintenance of it. So what do I mean by that? In order to be eligible for TDIU, you have to have a service-connected disability that is preventing you from performing substantially gainful employment. The severity of that service-connected disability matters as well. This is where the rating differs a little bit. So at least one service-connected disability rated at 60% or more, or two or more service-connected disabilities with at least one rated at 40% and combined rated at 70% or more. So you can be 70% service connected with at least one disability rated at 40%, or have at least one disability rated at 60%, and you have an inability to perform substantially gainful employment. I need to update that typo there because of the service connected disability. So what does that mean? Why does this matter? You could be rated at 60%. Let's say you have one condition rating at 60%. It's a back condition, but that back condition is severe enough not to be rated higher than 60% because you don't meet all the qualifications for the next level, but it is severe enough that it prevents you from performing substantially gainful activity, substantially gainful employment. Therefore, if you get all your ducks in a row and you're able to show that through evidence, the VA will pay you at the 100% rate. So going back to the numbers, let's say you were at 70% and you get individual TDIU or individual unemployability, you'll still be considered 70% service connected, but they'll pay you at this rate for as long as you're unable to work. And if you're asking, yes, you can receive VA service connected disability benefits, including individual unemployability and Social Security disability benefits at the same time. I'll let the mathematicians here figure out that your clients could be close to being financially set, depending on the cost of living area, if they're unfortunately in this situation where they're unable to work on their own. Now, let's talk about some periods of ineligibility, and these are common periods that pop up, and there's two that we're going to talk about. The first is, and we're just going to quickly bring these up, veterans who are incarcerated. So service-connected disability benefits get reduced to 10% if you're incarcerated for more than 60 days for reason of a felony. Now, you're essentially, there's no reduction for misdemeanors or community control or work release for service connection, but they get reduced to 10% if incarcerated for more than 6 days for a felony. And for VA pension, the benefits are not payable at all during period of incarceration for greater than 60 days for any reason, misdemeanor, felony, any reason. We'll talk about pension in the next slide. The other reason why you may be ineligible, and these are just two of the common reasons, is something called a fugitive felon tag. So benefits of any kind are not payable if it's determined that a veteran is fleeing an outstanding warrant for a felony arrest. There are a billion issues that can come up with this. One of them being the VA doesn't actually care if you're fleeing. Sure, it's part of the statute. It's something they're supposed to be working out. But if you have an outstanding warrant for a felony anywhere and the VA finds out about it and they do records, cross record tracking every so often, they will cut your benefits. They'll say, hey, first they propose. They say, hey, we're going to propose to cut your benefits because you are fleeing this warrant in, Tennessee. And so you got to figure out a way to resolve it. And what ends up happening is your benefits were now unpayable for any time that they have determined that you were fleeing an outstanding felony warrant. It becomes multiple layers of issues that need to be resolved. These cases end up popping up in batches because the VA will do kind of batch searches where they cross-reference records with the DOJ. And your client may have a bunch of issues that pop out of it, not just resolving the underlying warrant to get their benefits reinstated, but now you may have to argue back pay. Maybe they've had this warrant for 4 years and no one really knew about it for the past 4 years. And now they have 4 years of benefits that the VA is saying, hey, you weren't eligible to receive those benefits for the past 4 years, so you got to pay them back. So a bunch of issues that come up. Fortunately, the VA does have processes for resolving debt. But I personally love these types of cases. I love fugitive felon cases. Just got to handle one recently, and it's a lot of fun. But yeah, they're multi-layered and they can be quite difficult. Okay, let's talk about VA pension. So VA pension, we'll talk about some eligibility. We'll talk about 2 additional bolt-ons to VA pension called aid and attendance and housebound. Again, this is high-level stuff, very basic. Where we're not going to get into some of the details or any more details about service connection, really. And we're just going to touch the service about VA pension. But just so you know, also known as non-service connected disability pension, the veteran has to have been discharged under other than honorable conditions, served a minimum required amount of active duty with at least 1 day during eligible wartime period. Back to that question I was asked earlier, there's your answer. Depending if they served before the early 80s or after the early 80s, they have to have served that minimum required amount or meet an exception. And one of those days have to have been during an eligible wartime period. And also, as I mentioned, they have to either be permanently disabled, a patient in a nursing home, or over the age of 65, and meet VA income and net worth criteria. It sounds a lot like SSI. It is similar to SSI. It pays a little bit more than SSI. So we'll talk about how we calculate, maybe. Nope. We're not going to talk about calculations. Actually, I'll bring it up quickly. So similar to SSI, we have something called countable income that we have to look at. So the 2 numbers that we have to know when determining their income qualifications are what is their countable income and what is the maximum annual pension rate, or MAPR. And we do some quick math. The countable income is all of the income that they have coming in from any source, including VA benefits, Social Security, Medicaid, Medicare, whatever it might be. Any money that they have coming in is countable income. Subtracted by, any money they have coming in goes into the calculation of countable income. It's subtracted from 95% of their medical expenses, qualifying medical expenses, out-of-pocket medical expenses. So maybe they have really expensive prescription medication that they have to pay out of pocket for. Well, that is then they subtract that from their other income. The result of that number is their countable income. The VA will pay through pension the difference between the maximum annual pension rate and their countable income. I don't have the number in front of me. It's not a whole lot of money. I think the base VA pension maximum annual pension rate is about $11,000 a year. So it's $11,000 a year, maybe a little bit more, $12,000 a year, whatever it is, subtracted out their countable income equals how much the pension will pay. It is a supplemental benefit, just like SSI. And the calculation is similar to SSI. So keep that in mind. It's not really a great benefit on its face. Doesn't pay a whole lot of money. It's certainly better than nothing and pays a little bit more than SSI. How there are 2 additional bolt-ons that I mentioned, aid and attendance and housebound. And how do those help out here? What do they actually do functionally? Is they increase the maximum annual pension rate. So by if the veteran qualifies for either aid and attendance or housebound, they will increase the maximum annual pension rate. So if their countable income is 0, they will get all of the money paid out to them on a monthly basis for this. And it's pretty substantial. I think I don't have it in front of me, and I apologize. You guys can look it up on the VA website. But the maximum annual pension rate for aid and attendance, I believe, is something along the lines of like in the $30,000 range. So I'm sure someone's correcting me right now in chat. I'm sure if this is on YouTube, the comments are blowing up. But anyway, aid and attendance is for veterans requiring the aid of another to perform personal functions for everyday living. And housebound is for a veteran who is substantially confined to their immediate premises due to a permanent disability. Both of these require medical evidence to substantiate the claims. Aid in attendance is fairly subjective, but still requires medical evidence. I would fairly argue that if you have a veteran over the age of 65 who's getting VA pension, you better be interviewing them to determine whether aid in attendance is an additional benefit for them. Anyway, moving on, let's talk about spousal and widow benefits. So we're going to talk about DIC, pension, and apportionment. And I apologize if I'm going a little fast. We're short on time, and there's still a little bit more I want to get through. So DIC we talked about. It's available to eligible children and surviving spouses for veterans who either died in the line of duty, died as a result of a service-connected disability, or died as a result of a non-service-connected injury, but they were determined to be totally disabled from a service-connected disability. So totally disabled veterans who died. And there's some rules about when that applies here. The DIC benefit pays a monthly rate of $1,319 with some additional allowances, and that gets paid either to the eligible child or the surviving spouse. One important thing to point out is that when someone dies, when they're receiving service-connected disability benefits, those benefits stop with the death of the veteran. So the surviving spouse doesn't pick up those benefits. The benefits stop. The surviving spouse can apply for DIC benefits. They could also apply for widow's pension or survivor's pension or death pension. And that is, like I said, very similar to VA pension. The deceased veteran must have served during a wartime period. The surviving spouse or the eligible child's income must be below the pension rate. And they use the same maximum annual pension rate calculation as before. Let's go into claims procedures. So let's talk about a claim from start to finish. And that's how we're going to spend the rest of our time here, the last 22 minutes, talking about the initial claim procedures and going through some of the pitfalls that happen. So let's get to it. So here's the lifespan of a VA case laid out in front of you. First, it starts with filing a claim for benefits. We'll talk about the VA's duty to assist, how to reopen a claim, compensation and pension exams, and appeals. So here's the lifespan. All starts at the very beginning. A veteran will file an initial claim for benefits, or they can file a placeholder called an intent to file a claim, which we'll talk about in just a moment. The VA then will review that claim. They'll send letters to a veteran outlining additional evidence or actions that may be needed. They may request, like I said, evidence or have them attend an examination. Then the VA decides the claim. They send a written decision letter, written and hopefully dated decision letter to the veteran. That then it starts the 1 year appeals window to appeal the decision. You have 1 year. It's a long time. If you ever worked in a legal aid setting, you will know that many clients will come to you and be like, hey, I think I've got to appeal this decision. It's due tomorrow. So, you got to be quick on your feet sometimes and determining these cases in a legal aid setting. Happens sometimes in private practice as well. If the veteran wishes further recourse after they've gone through this appeals window and they've received another decision, they can appeal to the Board of Veterans Appeals, which is the administrative court. If they're not happy with the Board of Veterans Appeals decision, they can then appeal to the Court of Appeals for Veterans Claims, which is the federal court carved out just to hear controversies stemming out of this administrative process. And lastly, if you're not happy with the court's decisions, the CAVC, you can appeal it to the federal appellate court and so forth. I'll tell you, most claims bounce around in these three areas for a while. Sometimes they go up to the court, sometimes back. I have a case right now I'm working on that has been to the Court of Appeals for Veterans Claims. This is the fourth time it's been bounced between the board and the court. And we just picked it up now as his, fifth attorney on this case. So we'll see what happens. Hopefully fifth and last attorney. So let's talk about the intent to file. You can start a claim with an intent to file. An intent to file can be filed really at any time prior to starting a new claim for benefits. So what it does is it acts as a placeholder for an earlier date. And that earlier date becomes important later when we talk about the effective date for retroactive pay. The intent to file a claim only applies for the next initial claim filed. So if you file an intent to file today, Today, for those who aren't here watching it live, today's November 14th. If you filed a claim today, you then have 1 year to file a claim. If you filed then your next claim in January and then filed another claim in June, only the January claim is going to get the earlier date. So it effectively gives an earlier date to the next claim you file. And that can be important. Maybe you don't feel like you're ready to file yet. Maybe you haven't found the VSO that you want to work with, but you know you want to file a claim. You put in that intent now, and you hold that date for 1 year. Then you could just, next step would be filing the claim for service connection specifically. And you can file online using e-benefits. You could file using paper. You can go to a VSO. And this is the process for requesting the VA to review your disability benefits claim that has not already been previously adjudicated by the VA. Now, if it has been previously adjudicated by the VA and you're outside of that 1 year window, you wouldn't be filing a 526EZ, you'd be filing a supplemental claim. And the supplemental claim has its own form listed there, 20-0995. And that is for a claim that that's already been closed. You're outside the 1 year. And so what you need is you need to show new and relevant evidence, or, it used to be called new and material evidence. Now they call it new and relevant evidence. So new means not previously considered by the VA. Relevant means material, or it adds probative value to your claim. And supplemental claim can be filed at any time if you have the need for new and relevant evidence as part of the claim. But it's a great way to reopen really old claims that someone filed 50 years ago, or claims that their previous attorney may have missed, or maybe they went unrepresented and they may have missed their deadline. So the claim, even if they missed the deadline, claim could always be reopened. The problem is your effective date changes a little bit. And we'll talk about that in a second. Now, when submitting a new claim, the people will tell you the best way to do it is with a fully developed claim. That's saying that I'm submitting all of the evidence I have to support a claim. Now, what does that mean, submitting all the evidence? Well, the good news is your client does not have to wait to get their VA records, to get their military personnel file, to get their service treatment records, to get all the stuff in hand before filing a claim. Because as you're about to learn, the VA has a duty to help gather those documents. So a fully developed claim could very well mean that I have all the information I need to give to the VA. So I know what disabilities I'm filing for. I know where I got treatment. So I know the VA facilities, the government facilities I got treatment in. And here's another form that has releases for all the private doctors I'm seeing. And here's my military service information. If you provide that, that could be a fully developed claim just using the VA forms. And you're not submitting your own personnel files, you're not submitting your own individual private medical treatment records, but instead you're showing the VA and giving them the authority to go get it on your behalf. Now, the VA has what's called a duty to notify and assist, which means if you inform the VA that records exist, they have to make a reasonable effort to assist in getting those records. VA medical records, military records, other types of federal records, private medical records. They have the duty to help get those records, and they have to put in a reasonable effort. Reasonable effort doesn't mean they have to keep trying over and over and over and over again and give them a runaround to drag out the case forever, but they have to at least put in a reasonable effort. They have to make requests to get those records you need until they're reasonably sure the records don't exist, or if the custodians of those records are unresponsive. And so it's very important to understand the VA's duty to notify and duty to assist. They have to inform you that there's additional evidence to substantiate a claim. They have to inform you that there may be evidence missing, that additional evidence may be required. They have to assist you in getting that evidence. And it's very important. There's also here, when we talk about a compensation and pension exam, it's another part of the VA's duty to assist in building your record for you. I mentioned it very early on, but these are non-adversarial proceedings. It's not you, it's not veteran versus VA. This is supposed to be veteran and VA going together, navigating the law hand in hand to get the veteran claim adjudicated or pushed through, whether acceptance or denial happens at the end. So a compensation and pension exam, or C&P exam, is a very important part. And if it's necessary to substantiate the claim for disability benefits, the VA is supposed to have your veteran or have your client or yourself attend an examination to help establish additional aspects of the claim. The 4 elements here are the 4 elements from the McClendon case that are needed for when the duty to assist triggers, and the VA must issue a C&P exam. Now, by issuing a C&P exam, the VA merely just has to go and schedule it for your client. They have to say, hey, I've scheduled your exam with a doctor or an examiner who is familiar with your type of disability, who's going to use our VA forms to determine whether you meet the criteria or not. C&P exams are wildly disputed. They often end up being the huge basis for appeal, not just the fact of whether they scheduled an exam or not, but the substance of the exam itself are usually heavily debated. Sometimes it's the only type of exam your client will ever get in their disability claim. Sometimes your client will be able to get private medical records and private medical nexus opinions, like I stated earlier. But most of the time, oftentimes this is the only exam your client will get. Here are the 4 elements of when it's needed, or when the VA has a duty to schedule a C&P exam. And if you think about it, this all makes sense. So a C&P exam will be issued when competent evidence of a current disability or persistent or recurrent symptoms of a disability exists. So the veterans establish that they've met the first element of service connection. The second one is that, the in-service event, injury or disease or symptoms of a disease or manifestation during applicable presumptive period, that you've established that second criteria as well. So if you've established the first 2 criteria, you're probably on a good way to get a C&P exam issued. And it makes sense because the C&P exam helps establish that third element of service connection, that medical nexus. And that is, so now here, the C&P exam will be if there's evidence that indicates that a disability or persistent or recurrent symptoms of a disability may be associated with service. So it's very broad. It's a very extraordinarily low threshold, the third element here, of may be associated. It's written to be a low threshold. Evidence that symptoms of a disability may be associated, very low threshold. And fourth, obviously it makes sense. There's not enough medical evidence to push these things through, so an exam is warranted. So C&P exams, very common part of the service-connected disability claim. Now, once all the evidence is sorted through and the VA's reviewed it and they've gathered everything they've needed and supposedly they've followed all their duties to assist and notify, they have a decision letter, and they will put together their decision letter that will issue in writing an explanation of how they decided the claim. The letter includes evidence they used, a breakdown of each contention, so each disability that was reviewed, along with the rationale for each disability, and also their right to appeal. These decisions have to be clear. They have to have reasonable bases for their decision. They have to be explained for what the rationale was for each decision. The VA tends to miss the mark on properly explaining the rationale and saying which evidence they did review and didn't review, and it ends up being grounds for appeal later on or even immediately. It's often overlooked at the regional office level, but it's probably the biggest reason why cases get sent back and forth between the Board of Veterans Appeals and the federal court, is to sort out better explanations for denials, or them properly reviewing evidence that existed. So let's quickly talk about effective dates of claims. So an effective date of the claim, it really matters. And it's generally going to be either the day after discharge if the claim's filed within 1 year of leaving the military. Otherwise, it could be the date of the receipt of the claim, or the date that entitlement to the claim arose. And that is for effective dates of initial claims. Effective dates get a little more complex when you're talking about increases in disability benefits. There's other effective date rulings for that, but we're only really talking about that effective date of that initial claim when will the veteran be paid back towards? How much back pay will they get? So there's a couple things that we look at. We look at the date of discharge. So is this claim filed within 1 year of discharge from the military? If so, the date of their discharge will probably be their effective date. When did the VA receive the claim? Let's say they were discharged 15 years ago and they're just putting in a service-connected claim now that's getting granted. What is that effective date going to be? Is it the date that they filed that intent to file? Maybe. Is it the date that they filed that initial claim on the 526 EZ without an intent to file? Maybe. That could very well be that earlier effective date. Or was it the date entitlement arose? What does that mean? Usually, when we look at the date when entitlement arose, we are looking at something like some evidence got brought into the case that really tipped the scale, that didn't exist already, that changed the narrative, that said, well, before this evidence existed, the case, you weren't entitled to benefits. But now you have this evidence. Now this is the date entitlement arose. New evidence has been introduced to this case that really pushed the case over the edge to us granting it, to the VA granting it. And so the VA may argue, well, that's your effective date. It's when the date that entitlement arose. The most common thing that interrupts these cases is someone filing a supplemental claim. So they'll be like, you'll have a pending case. New evidence will come out on an appeal. In order to file that new evidence on the appeal, you have to file a supplemental claim. Well, now the VA might say, well, you filed this new evidence, and this is what tipped the scale for us. So that's your effective date. There's a lot of appellate work done around earlier effective dates because the date is what determines how much retroactive pay the client gets. And if you're a private attorney handling this, it also means it affects the amount of your fee because your fee is percentage based on retroactive pay. Effective dates are heavily contested and they're fairly complex. So that's why they get heavily contested as well. So you got to get good at this stuff if you plan on practicing it in the future. Let's talk about other evidence that can be used to support a claim. Again, we talked about broad types of evidence that can be used. And so the veteran, though, they probably doesn't happen too often. The VA oscillates between publishing disability benefits questionnaires and leaving them private and not available online. And there's always some active litigation about having those things publicly available. But completed disability benefits questionnaire, DBQ, is what the compensation and pension examiner uses to fill out their opinion. Some veterans will print out DBQs and bring them to their private doctors to fill out because they want them to speak VA language. They don't want them to get everything right. Hey, it happens. Personal statements from the veterans, buddy statements from people they served with, statements from a family member, SSOC forms, which are forms that we talked about previously. There's statements in support of a claim, anything else that will help establish the baseline for their claim. So the VA will accept all these types of evidence, whether they review them and how they weigh them or not for credibility is one thing, but they will certainly accept evidence. The rules of evidence as far as like hearsay and evidence that can be submitted don't quite apply to this administrative procedure, but make sure you review the VA's evidence regulation if you do practice this area. For filing non-service connected claims, it's a little bit different. The process can be fairly complex sometimes. Sometimes there's some Medicaid planning issues. There are some special needs trust issues, just like you may have in SSI or Medicaid planning. So I don't suggest that you pick this up as a tool that you offer in your belt of VA benefits unless you have an estate planning background, a tax background, benefits planning background, or you work with somebody who does, just because there are issues that may come up. So just something to keep in mind. As we talked about, you have the right to appeal. There are two different appellate tracks. Prior to February 19, 2019, there was something called the legacy appeal, that was the law of the land. Appeals all were done through what's called a notice of disagreement. You're asking for a de novo review by someone from the VA called a decision review officer. But these days we have the AMA, which is supposed to make things a little bit better for our veterans. So the Appeals Modernization Act that went into place on February 19th, 2019, established different tracks and different lanes for an appeal to get sorted out. And they're all listed here in the middle. We have the first one being a higher level review, supplemental claim, as we kind of discussed before, and the notice of disagreement, but this time to the Board of Veterans Appeals. So how do you know which one to pick? You've received the decision back from the initial claim. You're not happy with it. You want to appeal it. Which one do you pick? So higher level review would be your best option. If you're just asking them to, if you're asking the VA to review everything again, give a de novo review, give us a fresh review, and give us a secondary opinion. You can't submit new evidence with a higher level review, but you're asking them to give a de novo review with everything that's part of the claims file. You can submit argument. Legal argument is not new evidence. So you could submit a brief, you can submit legal argument, you can submit reinforce evidence that already exists in the record, but you could not submit new evidence. You couldn't like go get a medical opinion from a private doctor and be like, look, I've got something here. You couldn't do that through a higher level review. If you did that, you have to file through a supplemental claim. And again, supplemental claim must include new and relevant evidence. Higher level review versus supplemental claim, you probably want to do a higher level review first, especially if you don't have new evidence that's going to tip the scale. If you're just trying to provide clarification, being like, hey guys, you were supposed to do a CMP exam, and here's why, and you need to go back and do that and make these corrections, higher level review is going to be the way to go. If you've got like that smoking gun evidence, maybe that wasn't submitted the first time for some reason, supplemental claim might be your best way to go. If it's neither of those and the VA is just messing things up and you don't want to deal with a higher level review and you're done with them, you can file the notice of disagreement right to the Board of Veterans Appeals. And that's the administrative court that hears these cases from the regional office. Strategically, you might be thinking, well, why wouldn't I just always file to the board? Well, it takes a very long time for the board to hear these cases. And if it's just something that like a clarification, something that needed to be resolved that the VA overlooked, and you can eloquently explain it, maybe you'll get it resolved at the higher level review. You can ask for an informal conference with a higher level review. I had one the other week that with such an amazing VA employee. It was great. We were on the phone for 40 minutes. We got all of the issues resolved. He saved our client years of time from having to file an appeal to the board. So higher level review is a great tool to use, but sometimes you can't get it resolved at the higher level review. You ask, you know you're right, and they keep saying no, so you just have to file an appeal to the board. Now, in general, the veteran has 1 year to appeal the claim from the date of the decision letter. We talked about that, so it's important to know. Let's talk about after the appeal, and these are for older claims. So this is the legacy track. You filed the notice of disagreement. You weren't happy with the VA's initial decision. File a notice of disagreement. The VA will come back and issue a statement of the case. And in that's the VA's final administrative decision. That's important because that means you can then appeal different ways from there. It's the VA regional office's final administrative decision, technically, where you can now enter into the administrative court for the Board of Veterans Appeals. But you have to, in the legacy track, so if you have older appellate cases that are still under legacy, older VA benefits cases that are still under legacy, you might say, but James, that's 2019. Yes, unfortunately, 6 years later, 7 years almost later, these claims still exist. We still see some legacy appeals that have been back and forth from the board and the court and back to the regional office. So this is the track for legacy appeals, but more likely you're going to see AMA, Appeals Modernization Act cases. We kind of talked about, higher level review or supplemental claim going to the Board of Veterans Appeals. Once you're done with the Board of Veterans Appeals and you're not happy with their decision, which by the way, the BVA decision is only binding in this case at hand. It can't be used, it can't be cited elsewhere. So you can have a Board of Veterans Appeals case where a BVA judge says all this wild stuff. You can't cite that case somewhere else. It's not, it has no precedence. It's only binding to the case at issue, the case at hand, your case right there. Now, the Court of Appeals for Veterans Claims, if you're not happy with the BVA case, let's say the BVA is denied your case, you can then appeal to the Court of Appeals for Veterans Claims. You got 120 days to appeal to the Court of Appeals for Veterans Claims. And at that point, they'll sort out your case. The court can either affirm the decision by the board, so that they can deny your case. They can remand your case back to the board with instructions of why they got it wrong. Or sometimes the court doesn't even get involved and they just grant a joint motion for remand that the parties have agreed upon. We'll get to that in a second. And then, of course, the U.S. Court of Appeals for the Federal Circuit, and then the Supreme Court could hear those cases as well. You can imagine how infrequent that is. So for the CAVC, again, this is the federal court created to hear controversies from the BVA. Cases are docketed in the order that they're received. It's very pro se friendly, fortunately. It's at least pro se friendly up until the point where an attorney is talking to other attorneys through what's called a Rule 33 conference or mediation. But all cases go through that Rule 33 conference. Right now, there's a pretty big delay in getting Rule 33 conferences at the time of this recording due to staffing. We just came out of a recent government shutdown, which didn't impact the general counsel specifically, but we have been seeing a big slowdown in getting Rule 33 conferences issued. If the case is not resolved at the mediation at that Rule 33 conference, then it goes to the court. It goes to the court for briefing of the issues. Each party will have an opportunity to file a brief. So first with the veteran, the appellant files their brief, the appellant's brief, and then the government attorney will file the appellee's reply brief. And then you have an opportunity as an appellant to file your appellant's reply brief to the court. The court will then review all the briefs, review all the argument, and make a determination. Some cases are selected to be heard before a panel of judges in oral argument. It is not very common at all. It's actually quite rare to have a case selected to be part of oral argument. In fact, usually most of the time the cases are just handled for a single judge and don't have precedential holding to them themselves. So the last couple slides here, I talked about EJA fees. Prevailing claimants can get fees from the government. Successful cases get remanded back to the board for correction of the error with specific guidance. When you're writing, if you're going through the Rule 33 conference and you come to an agreement, that joint motion that you write with the government attorney is key because those are the rules that you're asking the board to follow to correct the error. As I mentioned, cases of first impression can create law, but most cases don't have precedential value to them. It's mostly just correcting errors that were missed at all levels of the agency of original jurisdiction and the board. So, a couple questions. Why VA law? Why would you practice this area of law? Well, there's so many benefits, honestly. I've been doing this stuff for a decade. I love it. It's a really great area of law to be in. You're helping people. You're really helping demystify this very convoluted process. It is a unique area of law. It's not overly saturated. I think I know all the other VA benefits attorneys that practice down here in South Florida, and they're all great people. I love the informal nature of this. Obviously, if you're doing oral arguments in front of the Court of Appeals for Veterans Claims, you're going to be putting on a suit. But most of law is fairly informal. It's administrative law. Yes, you have to write persuasive legal briefs, but there's not a whole lot of formal writing that you need to do. You can be more creative. You can be more persuasive in your writing. There's plenty of opportunity to take pro bono cases to hone skills. I'll give a couple shout outs in a second, both local and national. And there's flexible fee schedules that allow direct payment from the VA or from the government. So you don't have to hound clients for money, which is all the private practitioners out there. Clients are very appreciative of your service, but after you're done with them, maybe they are not quite some clients may forget that they owe you a fee, or may have sticker shock when they see how big the fee is. Well, this area allows those fees to be paid directly from the VA, so you don't have to worry about that. And just quick shout out to a couple of programs out there. Through Mission United, the Legal Aid Service of Broward County has a pro bono program that provides veterans residing in Broward County with direct pro bono placement. Always looking for pro bono attorneys to take cases in a wide variety of civil legal areas. Let me know if you're an attorney who's interested. Also, it is amazing some of the stuff that Florida Legal Services are doing as well with discharge upgrades and VA benefits cases. Shout out to them. We also work closely with Bay Area Legal Services and they have a great statewide program here throughout the state for veterans, based out of the Pinellas County, Hillsborough County area, St. Petersburg, Tampa area. They do some great work as well. On the national scale, we do a lot of work with the Veterans Consortium. They help get cases for our clinic at the federal court level. Great way to learn, feel well supported while taking a VA benefits case at the federal court level. You will learn a lot doing if that's the first case you take through the VA, the Veterans Consortium at the Court of Appeals for Veterans Claims. You'll definitely learn a lot. You'll have a great experience. And just nationally, there's a lot of great programs out there. If you're unsure, just Google and look into it. If you're part of a law school that doesn't have a veterans clinic, encourage your clinical staff, encourage your clinical professors and the deans there to pick up a veterans law clinic. It's been hugely beneficial for Nova Law School to restart their veterans law clinic. Been proud to help them restart that, and now I've been a part of it for just over 3 years. And always happy to help other law schools as well find ways to do it. Understanding money's always tight. As talked about, EJA fees could be a way to do it. So keep doing the great work out there. Thank you all so much for joining the webinar. And I'll let some closing remarks take place now.
All right, James, thank you for an amazing presentation. I dropped the CLE code into the chat. I'm going to read it out loud just in case for the benefit of the audience. The code is 2514915, N as in Nancy. This will all go out via email next week. I included the links for the VA accreditation instructions and the form as well. I've been compiling some resources, as James was talking. There were a few questions, James. I believe you answered them all right now, like mostly all. If for whatever reason we missed any questions, I know we went a little bit over time. Feel free to email me and I'll make sure James gets those questions. And we can go ahead and address those. I see Lynn raise her hand, so I can bring you off mute in a second, Lynn. James, there was something that you mentioned that caught my attention because it was actually connected to our last webinar. And I'm going to drop it here because I made a note of it. I think it might be easier to drop it into the chat. And it has to do with total disability based on individual unemployability. So during our last webinar, Christy Arkovich was addressing student loans. And the terminology is similar, but she mentioned total and permanent disability discharge. And it's a great benefit. She mentioned how she uses it for vets who has student loans that can lead to a discharge. So I may be wrong. I'm not the expert, but I wanted to bring it up. And I see you nodding, so hopefully I'm right. But anything you want to add on that on the student loans?
Nope. You and Christy 100% correct on that. That TDIU, even if you're not receiving the, you could be 100% service connected and be considered totally and permanently disabled, and not get the TDIU, but be considered totally and permanently disabled. That can open up a world of additional benefits. So if you're 100% service connected, or you get TDIU, and you have to make sure that the VA has marked you as totally and permanently disabled. But if you are considered totally and permanently disabled, you can apply for discharge of federal student loans. Here in Florida, you can get property tax exemption, full property tax exemption. So you're not paying property tax here in Florida for totally permanently disabled veterans. There's a lot of benefits that may open up for totally and permanently disabled veterans, but you have to make sure that the VA has you appropriately marked so that you can get the right paperwork to send in for those things.
Well, I think Christy Bagalow and I have some work to do and probably getting some future webinar together on downstream issues because there's a lot of other opportunities that come up for our veterans. So I know this is Tuesday was Veterans Day, and I did whatever I could to get James to do this webinar this week in honor of Veterans Day. So thank you for joining us on a Friday for a 3-hour webinar, a very informative 3-hour webinar. So I think Lynn doesn't have her hand up. It may have been inadvertent, and I know we're a bit over time. So out of respect for everybody's time, I'm going to wrap it up here. We're going to be posting the recording on YouTube next week. So James, thank you again for an amazing webinar. We all learned a lot, and we'll see you around. Have a great one, everybody.
Thank you.